OJ Simpson kills those two people so hard, they stop making the Ford Bronco.
Hey, everybody. Good morning, good afternoon, good evening. Hi, wherever you are. Whatever you're doing, it's me, Legal Vices. And it's that time of week again. It's OJ Simpson time. How are we all doing? Where are we all from? What are we all talking about today? Just looking at the pre-chat here. I see that we got lots of people from all over the world here, as usual. That's great. You guys have been keeping each other company while waiting for the show to start. That is always deeply, deeply appreciated. We've got mods. We've got lots of mods. Steph is here. Hey, Steph. Long time no see. Good to have you here. Valhalla awaits. Our newest mod is here, as always. Thank you so much, sir. Good to have you here. Who else do we have? We have Rose. Rose is here. Hey, mod Rose. Those looks like those are the three mods we have here so far, and we have all of you here in chat. Digger starting things up. I think OJ didn't do the actual murdering, but I believe he was watching. He enjoyed watching people. Yeah, there was that testimony, wasn't there? There wasn't enough time for him to do all that, shower, change clothes, etc. Well, that's the one thing we need to talk about. For those of you, well, we'll talk about it in a little bit when a few more people show up, so we don't have to repeat it again. Yeah, we see that we have our peeps representing Utah, Salt Lake City. Yeah, my family that lives up in Logan, they were sending me Snapchats all day of it snowing rather hard there in northern Utah. So I guess winter has found its way to Utah. So don't know if it's snowing where you all are. It snows about once every 2 years here in Busan because the city is literally surrounded by water on three sides. So there's not a lot of snow here, but it gets damn cold and humid at the same time. So, but it's still nice and warm here. It's about 65, 70 today. It's pretty nice. Hope you're all doing fine where you are. Well, we've got 103 here and only 50 likes. You guys should just know, just get in there and hit that like button as soon as you arrive. And it's always 50%. It's right around 50% if you just don't do your job to hit that like button. And thank you to all of you supporters. All of you helped us get over the 32,000 subscriber mark yesterday. That's a huge milestone for me, and I deeply, deeply appreciate all of the support that you guys give. Right now, we're at 32,019. So if any of you haven't, hit that subscribe button. I reached the goal. I reached several goals. I didn't expect to be here for another several months at the very least. So, don't really need to talk about subscribing much today because I'm really happy. All right, before we jump into the OJ Simpson trial, we've got a few things to take care of, a few administrative items, and then one more quick judge piece that has nothing to do with the OJ Simpson trial. Well, today is OJ Simpson Day. That's why you're all here. Tomorrow is F It Friday, the legendary monthly F It Friday Griftapalooza, Griftathon, begging for money, whatever you want to call it, stream, where we have all kinds of fun. It's, we throw away all concerns of monetization. We talk about things we just don't normally talk about and can't normally talk about when we're wondering, whether or not YouTube is going to like it. We just say we don't care. The whole purpose of F It Friday is, one, to grift really super hard so that I don't have to grift really super hard for the rest of the month. And two, to have all of you have a fun time. The rules are simple. $100 shots, $100 in super chats gets a shot of, this time, a 25-year-old Scotch. That's going to crush my soul, as I've said before. We can talk more about that tomorrow. And also, because people can continue to ask about it, I don't keep a lot of records of the ones that aren't the $100 things because they come in pretty quick and pretty furious. But I kind of keep a general eye on it. And if it seems like the less than $100 super chats total 100, then I'll usually take a drink as well. So even the ones that are below $100, those super chats count just as much. Just the aggregate, when it gets around 100, we do another shot. We do the really expensive ones for the $100, and we do the other whiskey for the ones that total less than that. But the whole idea is just to have fun. I don't even have the list up of things that we're going to talk about tomorrow. Let me bring up this list. A pastor who went crazy because, I'm some of you may know that I'm kind of a watch aficionado. I collect watches. But there's a video of a pastor who is going kind of off the rails because his congregation wouldn't buy him a luxury watch. He'd been asking for it for a year. They wouldn't give it to him. They didn't give him enough money for the watch, so he went off the rails. We're going to be talking about how racist House of Dragons is. We're going to be talking about a Chinese drone robo-dog. And we're going to be talking about a university student who got a letter addressed to Ching Chong. Some soft sit stuff. Models getting married. An Apple executive who liked boobs more than his job. A Supreme Court assassination. And we're also going to have some guests. We always have guests on F It Friday. We're going to have a lot of guests this time. So far, we let's see. Let me check my guest list. The current guest list for tomorrow, we will be hearing from Drex. Those of you that love Drex, he's going to be here. Those of you that hate Drex, he's going to be here. We'll have Drex. That Star Wars girl says she's going to pop in a bit. Christina Radix Verum, who was on last night, she'll be popping in. Aussie Overlord will be here. Meme Copium. Farron Balance is going to kick in. Nina Infinity says she's going to try to stop in. Good Logic Joe says he's going to try to stop in. And so we're sending out the invitations. We're still getting more people saying they're going to come in. Legal Bites, not going to be here. That kind of tipped everything off last month when I was on. Yeah, we had her last month, and that kind of kicked off the whole drama. So it was semi my fault. But so those are the people that are going to be coming. And that's going to be tomorrow, where we're just going to have fun. That's the whole point. Have fun, have drinks, sit around, talk. I grift for money. We're all happy. It's all tongue in cheek. People are like, you're just all about the money, and you don't want to get drunk on stream and just get money. It's all in fun. It's all consenting adults. It's been something we've done for months and months and months and months. So don't get your panties in a bind. Don't get your knickers in a twist. We're all going to have fun tomorrow. And then next Monday is Maritime Monday, which we always do. And that will be a maritime incident whiskey tie-in. So that should be fun. Nicole was asking about the hat, was commenting on the hat. This is a wonderful, wonderful hat from Aran Sweater Market in Ireland. It's a beautiful, beautiful hat. They make all my flat caps. I get all of my flat caps from Aran Sweater Market in Ireland. So Irish, peace. It's the ancestors. My mother is half Irish. All righty. Trot Golfer says, Legal Vices, people paying you to drink. You have it all figured out. Well done. As like I said, it's just all in fun. It's just, how dare you not drink for free? Oh, we do that. We definitely do that. But that's just the whole thing. It's just what F It Friday is all about. Come tomorrow. You'll have a good time. Enjoy it. All right. Well, as always, OJ Simpson on Thursdays. We've been doing for the past 5 weeks, I guess. We've been doing F. Lee Bailey's cross-examination of Mark Fuhrman. Again, F. Lee Bailey, one of the greatest defense lawyers ever to walk planet Earth. His mind was incredible. Unfortunately, if you want to look into him a little bit, the last few years of his life, he kind of tarnished that legacy. But, man, good stuff. His mind, his oratory skills, his oration is impeccable. His delivery, his intonation, his authority comes straight across. And his victim in this is Detective Mark Fuhrman, who just is a very quick background, because I know these backgrounds get longer and longer and longer as we go, but I'm going to keep this very, very short. He was a cop who found all of the important evidence in the case. He found the blood on the outside of the Bronco, of OJ Simpson's Bronco. He found it when he was alone, where other detectives couldn't see him, in a place where he was not asked to be, didn't tell anybody where he was going, and just kind of wandered down there. And then, he found some blood. And he found the bloody glove behind the bungalow where Kato Kalin and his sister were staying. Again, he didn't tell anybody he was going there. He went there all by himself without telling anybody he was going, without being asked to go there. And lo and behold, he discovers one of the most important pieces of evidence. But oddly, he said that he thought the killer may be back there, so he was cautious. How was he cautious? He went in alone in the dark with a tiny little flashlight. But he also mentioned cobwebs hitting him in the face as he went in, which if someone had gone in there before him, there probably wouldn't have been cobwebs hitting him in the face. And did he preserve the crime scene, run back and get all the other detectives? Nope. He walked out, brought one in, walked out with that person, got another detective, walked in with him alone, came out alone, got a third detective. Basically, he tracked 18 different sets of tracks through this potential crime scene, destroying any evidence of who, how, or why that glove was there. And also during cross-examination, F. Lee Bailey has caught him in several, depending how you look at it, lies or misspeaking events, such as when he was talking about the glove. Where also with the murder scene, he was supposed to be waiting on a street corner for someone to take him to OJ Simpson's house. But he admitted to finally, he said he stood there all for 90 minutes doing nothing. But then he admitted to kind of wandering around near the bodies. And he said that talking about the gloves, he said, and I saw them by the male victim's feet. Them being plural, but there was only one glove found there and one glove found over at the crime scene. He was caught in a lot of inconsistencies like that. And now what happened at the end of last week, they shifted gears to one, his financial gain, which comes into play here in the beginning. His financial gain in making sure that OJ Simpson is convicted. He'd filed a defamation suit against the defense lawyers and I believe at one or two media outlets for suggesting that he planted evidence and was a racist. So F. Lee Bailey was pointing out that he had a financial advantage in making sure that OJ Simpson was found guilty, because if he's found guilty, then that would be saying he didn't plant evidence, whatnot. It would be evidence to support his civil claims of defamation against the other parties. But they also mentioned a letter from Mark Fuhrman's lawyer saying that there had been $100,000 of expenses incurred in preparing for this defamation trial. And what was essentially old school crowdfunding. This letter was sent out to other lawyers, police officers, and whatnot, trying to raise money to pay Mark Fuhrman's expenses with his lawyer. Well, the defense wanted to put Mark Fuhrman's civil lawyer on the stand to talk about this letter, claiming to have incurred $100,000 in expenses and asking people to foot the bill for Mark Fuhrman. So boom, we've got that. And then because they didn't have the letter with them, they said, we'll get it and then we'll bring it to court. That happens probably next week. So from there, they shifted to racism. Mark Fuhrman being the racist. He had previously been hanging around a Marine Corps recruiting station. He was a former Marine, and F. Lee Bailey was a former Marine as well. He was like a badass fighter pilot. But Mark Fuhrman was hanging around a Marine Corps recruiting station and talking to two people in the recruiting station. We'll hear their names here in a minute. But one lady who said that she wasn't a fan of Simpson wrote a letter to the defense. Wrote a letter to the defense counsel saying, wait a minute, I was upset because I was heard that people were saying that this police officer is racist and whatnot. And, the fact they would try to bring this race card into it was upsetting to me until I looked at the television and I saw who they were talking about. And she mentioned a story that where she had been there on this day. He was at this recruiting station and he was dropping N-bombs saying that a black man, if he ever came across a black man and a white woman in a car, he would find a reason to pull him over. And if he didn't have a reason, he would make a reason, that all N-bombs should be gathered together and killed. She said that he was saying all of these things, and her purpose for coming forward was saying that, I don't want anybody to be a victim of this guy who is more racist than you could even begin to think about. So they asked him, have you ever, and back then, F. Lee Bailey dropped the hard R N word repeatedly in his questioning of Mark Fuhrman. Did you ever say this? Did you say this? Did you say this? And he denied all of it and basically said that anybody who said he was doing that was lying. And because of this trial, we've mentioned it before, so if you haven't heard it this time, because of the OJ Simpson trial, today we actually use the term N-word instead of actually saying the N-word. And that's because F. Lee Bailey dropped it so many times, and later we'll hear some recordings of Mark Fuhrman dropping it even more times, that Darden, the black prosecutor, refused to say the N-word. He started calling it the N-word. And so because of this trial, that sort of caught on. And after OJ Simpson, basically people stopped saying the word and started referring to it as the N-word. So that's the history of the term N-word. It comes from the OJ Simpson trial. Now today, where we pick up is a big clash between F. Lee Bailey and the prosecutor, Marcia Clark, about the people that were mentioned that were hanging out at the Marine recruiting station. The first good portion of today is going to be this battle between counsel. And we've been critical of Marcia Clark, but she came in fast and heavy on F. Lee Bailey. A general preview of what happens. One of the guys, they said that, they were, we'll just watch it and we can explain it as we go along. But before we do that, the Parkland shooter trial is concluded. The judge finally gave her sentence of life in prison without the possibility of parole for everybody. He's never going to see the light of day again. But we talked about it a little bit yesterday, the inappropriate statements she was making and kicking the defense lawyer out and just being, generally non-judicial. Whereas again, the defense people were probably pieces of crap. They were disrespectful. They did dumb stuff they shouldn't have done. They did questionable things. But a judge has to be above that. The judge has to be impartial. The judge cannot let her emotions get the best of her. No judge can do that. The judge is the arbiter, is the neutral position that just applies the law and the facts and the sentences as they see them. You cannot have a partial judge. She was biased. Nicola Maxwell says, I had no idea that's why folks say the N-word. I was obsessed watching this trial with my dad. Nostalgia. In other news, Jeff has a lovely community. I have the best chat in the entire YouTube. So there you go. So today, after the sentencing, she did something so incredibly wild. I have never, ever seen anything like this in my life. I'm sure you may have already seen the video, but I need to get this off my chest. This will be really short. So, I have never seen anything like this in my entire life. This was incredibly inappropriate. This is after the trial's over again. Everybody is kind of mulling about. These are the families, and they're all congratulating each other, and you got the happily it's over people. You got Negan back there, so they're all congratulating each other. Then the judge comes in. The judge is mixing and mingling with the prosecution right now. And that's a little bit odd. The judge, speaking with the prosecution, but she goes a step further and starts hugging the prosecution. All of them. One by one. And, it may seem, it may seem okay or normal to some of you. But any lawyer, go through YouTube, all the LawTube, whatever you want, and search for lawyers reacting to that. 100% of them will tell you that was highly inappropriate. From that, if I was in her courtroom with a defendant, I could never, ever trust her to be unbiased and neutral to go around hugging on the prosecution after it's over. That's just stupid of her to do that. That's just dumb. I mean, it's unethical. It's inappropriate. And I just wanted to point that out. I mean, it's stunning. Again, it might not mean much to just the average person. Go, okay, so what? But you just don't do that. I mean, that's just not something that happens. So let's burn through a few of these super chats. We've got 2 super chats. All right. Both of them from the same person. The first super chat of the evening, just a map nailed to the wall, set a goal of not being so gay. Hey, you got to do it. And again, you should have to take a shot every time YouTube takes the stream down for copyright infringement. Nah, that'd be no fun. You don't want me down and out from the beginning. Thank you so much for the super chats. All right, let's get into the OJ Simpson stuff. I just had to get that off my chest. That was crazy. It does not happen. Excuse me, sir. Where'd that go? Excuse me, sir. Stop attacking the hottest thing in a robe I've ever seen. Well, yeah, she shouldn't be inappropriate. She'd be hotter if she was ethical. I like hot and ethical, not hot and unethical. All right, anyway. Again, the first good chunk of today is just going to be this battle between F. Lee Bailey and Marcia Clark that gets pretty heated at times and pretty insulting. All righty. There we go.
Good morning, counsel.
Volume here.
All right, back on the record in the Simpson matter. Mr. Simpson is
No-
present before the
no
court
closed
with his
captions.
counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. Counsel, is there anything we need to take up before we invite the jurors to join us?
There is, Your Honor, partly because I personally represented to you yesterday that I had spoken with Max Cordoba, and because you may have heard reports that he gave a conflicting statement. I want the court to be reassured that I did indeed, about 2 weeks ago on a weekend, from Mr.
Okay, this Mr. Cordoba was in the Marine recruiting station. And their investigator, the defense lawyer's investigator, contacted him and was talking to him. And F. Lee Bailey apparently said that, hey, this guy was a Marine. I'm a Marine. I just wanted to say hello to him as a Marine. And then I believe it was Inside Edition. It was just they'll talk about it in a second. He was either Inside Edition or hard copy of the TV show. Called the guy that F. Lee Bailey said he had talked to. And the guy said, no, I've never talked to F. Lee Bailey. And so that's how fast this paparazzi news was and probably still is. He says it in court, and by 6 p.m. that night, the news magazine on TV has this guy saying, no, F. Lee Bailey never talked to me. So Marcia Clark goes apeshit, saying that he lied to the court, and then it's on. These two go at each other for a good 45 minutes.
Mr. Cochran's office.
And let me know if you need me to adjust the volume.
Mr. Cordoba, Mr. McKenna was talking to him and interviewing. He called us. McKenna recognized his voice. They had spoken before. He handed me the phone just to say hello as one Marine to another. I did that and handed the phone back. We reached Mr. Cordoba last night, and he said, yes, that's correct. I was confused when the fellow asked me the question. But the disturbing thing is that NBC would air that statement nationwide without picking up the phone to call either myself or Mr. McKenna, whom they're perfectly able to hound when they want something. They know where we are at all the time. They could have avoided this whole mistake. And that level of journalism is sinking way below what one expects of NBC. And I'm very upset about it. And I have reported it to Dateline, and I'm expecting a correction this evening when the matter is pursued. More to the point of this trial, Your Honor, you had ruled out the testimony of Mr. Coleman, who runs the ladies' wear shop next door. I believe that if one of the inferences that could be drawn from the conduct of Detective Furman was a deliberate racial slur, that should be a jury question and not for the court to rule out because there are other options.
Mr. Furman, would you step out, please?
And now they're having Mark Furman step out because they're going to talk about these other guys. Plus, they're going to talk about him.
Well,
I'm
Counsel,
not asking the
let
court
me-
to change its ruling.
Let me finish hearing from Mr. Bailey.
I'm taking a legal position, Your Honor, and because what we have is a letter from Mr. Coleman, in order that this subject can be properly scrutinized on appeal, in the horrendous event that should ever become necessary, I'm asking that you give me the opportunity to put Mr. Coleman on the stand out of the presence of the jury and have him tell you exactly what happened and the way it happened, so that a reviewing court can decide whether or not you've preempted the jury from deciding a question if the question as to what the conduct meant is a factual as opposed to a legal question. Second, Mr. Coleman corroborates Max Cordova because after Detective Furman called him a nigger inside the building and followed him out to the parking lot and did it again, Cordova came to Coleman's place of business. Coleman remembers the incident and said, I had to calm him down. He was very upset and he was very excited by the whole thing. Now,
Well, that's a different offer of proof.
I understand, and I'm bringing that to your attention because I learned it a short time ago when I called to see if Mr. Coleman would be available to come down and make an offer of proof on the record. That to me.
Now, Coleman never comes down to give the testimony. I didn't remember that he was dropping the N bombs this early in the day. I thought it was going to be about an hour from now. The N bombs come continuously throughout the day. so keep that in mind. But yeah, so he wanted to call this Coleman as a witness. The judge wouldn't let him. And so he said, well, why don't we just put him on the stand and questioning him outside of the presence of the jury so that if we ever have to have an appeal, then the appellate court can decide whether or not his testimony would have been relevant. But that's what they're talking about. And he corroborates this Cordoba's statements about dropping the N-bomb.
Is the best possible form, and we think it would be worth the court's time to preserve it.
How about a statement in writing? I don't want to take up the court's time doing extraneous hearings all the time, counsel.
All right. Now, if you can enable me to understand, Your Honor, you have a rather elaborate statement on the first part. Cordova, it seems to me, is a separate issue entirely.
I agree.
And his testimony would be relevant if Cordova testifies, as he told Dateline he would last night, and is attacked on the ground that he made the incident up. Other than that, I'm not sure that a prior consistent statement would be admissible, but should it be termed a recent fabrication on Cordova's part, and that's the drift I get from this side of the table, then the fact that he said that to Coleman hard on the heels, even if it's not part of the res gestae, would become admissible under California law. I don't think that question is going to be presented to you as to the Cordova part, unless and until that attack is made. I do think that I would like a better form, and if you're suggesting I rewrite or we put together a new, more formal statement, since those were all Mr. Coleman's words, pinpointing the issue that we wish you to take another look at, perhaps. I'll be happy to do that rather than take up the court's time putting him on the witness stand. I don't think it would take long, but I'll be happy to pursue that.
All right, I think you have the direction from the court.
Okay. Now, in addition to that, Your Honor, we have a case that we would like the court to consider. It is a court case that was thrown out because Detective Furman lost a door in which a bullet hole was supposed to be, called the Gould case in the Superior Court. We believe that his conduct in that case is relevant to this one.
And see, this is Mark Furman had a history back from the time when he was in the Marine Corps of not being an upstanding person. And here F. Lee Bailey is talking about a case where evidence was lost by Detective Furman. the evidence was a door. Somehow, Mark Fuhrman happened to lose a door with a bullet hole in it. Oh, and while we're stopped here, we'll get the super chat out of the way here. That one chick says, going through a lot of struggles right now, and the last few days have been rough. I was happy to see you were streaming, and thanks for making me laugh. I'll try to make people laugh today. This is kind of hopefully we'll be funny today, but I hope things get better for you. You know, just you try to find the humor here. If not, if you don't want to laugh with me, laugh at me. And this lawyer seemed comfortable with the use of that word, no hesitation. That's the beauty and the power of F. Lee Bailey. He comes hard. He knows the effect it's going to have. And also, he is using that word specifically because he's saying that Mark Fuhrman said it. He doesn't want to couch it in innuendos and euphemisms. He wants the word said because it has the impact. And Nicola Maxwell says, N-bombs weren't as bad in that day. Now people freak. Guys, bash the like button. Let's do that. Yeah, people freak now because of this trial, because it just became accepted to say the N-word. So, yeah, let's hear about the other case involving Mark Fuhrman that F. Lee Bailey thinks is relevant to this one, where he lost a door. Oh, and by the way, my standard disclaimer, I'm not doing this case to make anybody change their mind on whether they think OJ Simpson is guilty or not. It's been 27 years. You've made up your mind by now. Nothing I'm going to say, nothing we're going to show here is probably going to make you change. I'm doing this. I'm doing the highlights of some of these cross-examinations to show you how masterful lawyering can place reasonable doubt in the minds of a jury. If you think OJ Simpson didn't do it, you're going to say, oh, yeah, see, this is great. He was lucky to have such a great lawyer that could raise these issues. If you think he did it, if you're sure he did it, if you know he did it somehow, then I'm hoping you'll walk away from this saying, okay, I can see how a masterful lawyer like F. Lee Bailey or Barry Scheck, who we're going to review later, how they can plant these seeds of doubt in the minds of a jury, and how they can, through their oration, through their logic, through their reasoning, through their questioning of the police witnesses, the forensic people, and the prosecution's other witnesses, through that questioning, they can raise doubts. That's the purpose of this, to show you how a skilled lawyer can look at evidence and plant those seeds of doubt. Let's get back to it. Yes, Mark Fuhrman collected Nazi medals. he now, yeah.
I'm going to ask you to take another look at the Britain case on which you previously ruled, perhaps with some additional facts. Beyond that, Your Honor, the phones are ringing and ringing hard. People calling in who watched the detective and now wish to offer evidence contradicting his claims. And as these people come up, as rapidly as I can, I will submit them to the court as a proffer, the way I did originally, and then await your direction as to what, if anything, must be turned over. But this is an ongoing process, and I expect it will continue for some days.
All right, thank you. Ms. Clark.
I think I'd like to play tape to the court. Because not only did Mr. Bailey make a direct misrepresentation to the court yesterday, he's done it again this morning. And I think.
See, now she is just flat out calling F. Lee Bailey a liar. And people are talking about, well, Christopher Lee was collecting patches and Nazi things. Christopher Lee spent the entire World War II killing the Nazis, as Churchill called them. We have to pronounce it Nazis so that the YouTube people don't freak. But yeah, Christopher Lee was also SOS. He's the SAS in World War II. And for those of you who don't know, Christopher Lee, who played Count Dooku or Saruman, he was reportedly the inspiration for James Bond, like the character James Bond, because he and Ian Fleming were in the service together. So Christopher Lee, the actor who's been in a million things, was a genuine badass. He was a genuine badass to the point where he apparently inspired the James Bond character. So anyway, I don't think we should be comparing Christopher Lee and Mark Fuhrman.
I think that the, as I said yesterday, As I predicted, the tape would be very illuminating and provide the court with some very graphic evidence of the way counsel takes his role as an officer of the court so lightly. I want to play this tape now so that the court will be reminded of exactly and precisely the language Mr. Bailey used yesterday when he sought to misinform and mislead this court as to the nature of his contact with Mr. Cordova.
All right, Ms. Clark, what is this a tape recording of?
I'm sorry?
What is this a tape recording of?
His appearance in court yesterday, in which he stated to this court, in which he stated to this court that he had a conversation, Marine to Marine, with Mr. Cordova, and that Mr. Cordova told him, not Mr. McKenna, him, the statements that he later reported to this court.
You're referring to the comments by Mr. Bailey at 18606, beginning at line 15.
We don't have a transcript, Your Honor.
We don't either.
Yes, you do.
So yeah, she's called a 40-year defense attorney a liar in open court, and F. Lee Bailey
18606
isn't going to take
starting at
that
line 15.
lightly at all. And while she's bringing this up, just wanted to point out that I have my official Johnny Depp Mega Pint Legal Vices Pimp Cup full of a mega pint of wine. Just thought I'd mention that.
Mr. Darden and Miss Lewis about this incident, and they shut him off. They said, we're only interested in what Miss Bell said. And that's what he will testify to. And, Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever. As far as discovery is concerned, there is no written statement. There are no notes that I know of. And I heard about this because he called us, wanting to make it known that these people had tried to suppress this information. I spoke to him personally. I don't ever take notes, and I didn't on that occasion.
All right. That is not what Ms. Clark says. I said I did not claim that he related the incident to me. I said I spoke to him, and I have no doubt that he'll appear, and I don't have any doubt.
All right.
This is the kind of nonsense that gives lawyers a bad name, Your Honor. You know, it's very clear what he said to the court and what he was intending to convey. He was intending to convey to the court that he had personal knowledge of what this man said because this man said it to him personally, Marine to Marine. And now he's standing up and hair splitting with us. I never said he said this to me. I just said he spoke to me personally. That's nonsense. That shows you what we have over here in the way of ethics on this side of the table. They'll get up and they'll misrepresent to their heart's content until they get caught. And then they have excuses. And then they start splitting hairs. And then they have, well, this means this. And oh, no, that means that. I feel like we're in Alice in Wonderland. We've got Jabberwocky here. Nothing means what it says it does. No means I don't remember. I don't remember means no. Same thing. Now it's coming out of the mouth of Mr. Bailey. But that's exactly what we can expect to happen when the witnesses take the stand. If we rely on his offers. And we have not been able to reach Mr. Cordova, we need to talk to this man personally. I can assure the court, absolutely. No one cut Mr. Cordova off. No one refused to listen to him. As a matter of fact, Mr. Darden kept it, tell us more, tell us more. Please, is that all you have? Is there anything else you want to tell us? And with respect to Mr. Cordova's prior statements, they've been aired on national television.
I wish she would have had this passion in her opening statements. She gave that weird, rambling, dull, backwards opening statement presentation where she was talking about comparing DNA evidence to Jurassic Park and weird shit like that. She should have had this kind of fire in her opening statement. And Stina G says, that's not a mega pint, that's a redneck wine glass. This is the exact glass that Johnny Depp had in the video where he was assaulting cabinets. I know, because I got it. Well, it's not the exact glass, it's the exact tile glass, which is also a redneck wine glass. That's what he was drinking when he was talking about mega pints. So there you go. It's the official Johnny Depp mega pint Legal Vices Pimp Cup. Back to Marcia Clark, and F. Lee Bailey is stewing and ready to explode.
I mean, if Mr. Bailey doesn't know what he said before, I guess he's never turned on his television set. But they're a matter of record that all the world has seen. So if he is now claiming to have heard something as volatile and inflammatory as what Mr. Bailey is representing, we do have some serious impeachment. But no one cut that man off. We did not have the opportunity to speak to him, so we do not know exactly what he has, what he's going to say at this point. I certainly do not feel comfortable accepting anything that that Mr. Bailey offers to this court, especially in view of what we've heard. And I would like to play the clip for the court from Mr. Cordova, because Mr. Cordova, when given the opportunity to say, I spoke with a member of the defense team, I spoke with an investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Bailey, you can see how agitated he is, has been caught in a lie.
Ooh.
And you know something, not in this case, you don't get away with that. There's just too many people watching.
And that is the thing. They were playing to the cameras big time back then. This was one of the first. It wasn't the first. It was one of the first cases, though, to go from gavel to gavel on television. One of the very first televised trials. And as you see, the camera moves around, the camera pans around, and she knows that the people are watching. So she's throwing that out there. He can't lie because the world is watching. She's playing this for the camera, not for the jury. Well, the jury's not there right now, so she's got to play to somebody, and the judge ain't taking it. So, yeah, she's calling him a liar and saying that he can't weasel out of it because the world is watching.
You know something, not in this case, you don't get away with that. There's just too many people watching.
I object to the lack of foundation for this tape. Excuse me, don't play the tape while there's an objection. If Ms. Clark is going to take the stand and authenticate the tape, let her do it. But tapes are not self-authenticating. We've had no chance to see it, as you always require, before we're allowed to show anything to you. And I'd like to know where it came from and what it represents.
It's not before you can show it to me, before you can show it to the jury.
Right.
All right, Ms.
I'm
Clark,
just
what
showing
is
it
this?
to the court, if you please, Your Honor. It's self-authenticating. The man on it says he's Max Cordova.
Well, no, we've gone through the self-authenticating argument before, which I did not accept, if you recall. But being that as it may, what is this?
This is the tape of an interview with Dateline, which was conducted
Dateline.
yesterday
Sorry.
after Mr. Bailey made his representations that he had spoken to Max Cordova. After he made those representations in court, Dateline went and interviewed Max Cordova and asked if he had had an interview with Mr. Bailey, Marine to Marine. And Mr. Cordova said, no, I did not.
Which answer is correct?
All right. Do you have an extra copy, by the way?
He's got a new partner to solve this mystery.
That's Bill. That's Bill Cosby, Ms. Clark.
Bill Cosby, who also just got out of jail. Cough, cough.
Aware of that, Your Honor. We're not offering Bill Cosby at this time. And while he's queuing it, Your Honor, if I may request that the notes Mr. McKenna surely must have taken as a responsible investigator of that interview that we now learn occurred, which obviously Mr. Bailey did not want us to know yesterday. We want the notes of Mr. McKenna's interview with Mr. Cordova yesterday.
No, Sean.
You know, it's interesting that other states have rules of reciprocal discovery that require at least some offer or indication of anticipated testimony in their reciprocal discovery statutes, which is something California does not have.
I find it interesting, though, that it would appear the investigators for the defense in this case have prepared reports and taken notes on all other witnesses, but surprisingly, nothing on this one.
Well, I assume that's something you'll cross-examine on.
Probably fair to assume.
She's getting snarky today.
Well, Mr. McKenna, a witness at the very least.
Yeah, so they're going to play this video from Dateline.
Ms. Clark,
where the guy says he
Who
never
tape
talked to
recorded this
Bailey.
for you?
Susan? Our Media Relations Department did, Your Honor. After contacting Dateline to find out when the interview was conducted.
And are you representing to the court that this is a videotape of the Dateline broadcast? When?
Last night, Your Honor. This is a videotape of the Dateline broadcast last night, an interview that was conducted with Max Cordova after Mr. Bailey's representations to this court yesterday concerning his contact with Mr. Cordova.
Jenny B asks, how many days into the trial are we? We're not taking it day by day. We would be here for about the next 15 years if we did that. We're just highlighting some of the cross-examination points and some of the other witness testimony that I think is particularly relevant to showing how the seeds of doubt were placed in the minds of the jury. We are 5 days into this cross-examination here on the show, but 2 days in court time.
That he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever.
No, I have not talked to F.B. Bailey.
If you believe Max Cordova, and the defense hopes you will, then Simpson's defense team has some explaining to do. Because today, in our exclusive interview, the ex-Marine and potential witness said he didn't know what F. Lee Bailey was talking about. That if he'd spoken to the famous attorney, he'd remember, and he doesn't. Never talked to him.
No.
You know who F. Lee Bailey is?
Yes.
Pretty distinct fellow.
Yeah.
Pretty distinct voice.
Correct.
So you haven't talked Marine to F. Lee Bailey.
No.
But Cordova told us he does remember talking to Furman, and what he now says Furman told him ignited a heated debate today in the courtroom.
Max Cordova wanted to tell Mr. Darden and Miss Lewis about this incident, and they shut him off.
By the way, that representation will be disproven as well.
Okay, so Jonathan Smith saying, wouldn't that dateline be hearsay as it could have been edited? They're not, the jury's not in the room here. They're not trying to get it in to prove anything. She's trying to play it to just prove that F. Lee Bailey lied in court. F. Lee Bailey lied to the judge. So it's not being introduced for any evidence of guilt or innocence. She's just throwing this down here to show that F. Lee Bailey lied.
Now, Mr. Cordova had the opportunity to say, well, yes, I had some brief conversation with Mr. Bailey, but we didn't discuss the content of my testimony. Or yes, we had a brief contact. He said hello to me. Mr. Cordova said none of the above. He had the opportunity as well to say, Mr. McKenna spoke with me. I know he's a defense investigator. He did not say that either.
All right, Ms. Clark, let's assume for the sake of the argument that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Bailey should be cited for contempt and fined substantially. As an officer, as officer of the court, he has lied to this court. He is impeached by his own
I
witness.
ask that you put a stop to it. Either
Mr.
put
Bailey.
Cordova on the
Excuse
stand
me, Mr.
or
Bailey.
stop her from
Mr.
Stand
testifying.
up and speak when it's your turn.
Mr. Bailey, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordova makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Bailey got up to represent to the court this morning. Mr. Cordova was confronted with the statement that Mr. Bailey made, that they spoke. He said, no, we did not. And I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
All right, thank you, Ms. Clark. Mr. Bailey, do you wish to respond?
I do, Your Honor. And I do not appreciate being called a liar in any court. And I will ask at the proper time for correct action to be taken against the offender. The proper way to proceed, if there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence.
Now that answers the question that Mr. Bailey, control yourself. That answers the question that Jenny B asked. Well, not Jenny B. This is what was the judge's name? Judge Ito. Is he still a judge now? He hasn't been a judge for a million years. This was 27 years ago. He's just an old retired guy now. Matilda says, what if Cordoba lied to Dateline? He wasn't under oath here. He explains it later that he was a misunderstanding and he misunderstood it. But what F. Lee Bailey is saying here is the correct answer to that question. If you think he lied, if you think he wasn't telling the truth, put his ass on the stand under oath and ask him, did he speak to me or not? F. Lee Bailey is 100% correct here.
Proper way to proceed, if there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence. What they eliminated from the tape that I saw on NBC News this morning was that Stone Phillips said, why didn't you mention these things before? He said, I only give very narrow answers to every question. As he explained to Mr. McKenna last night, he did not have an interview with me, nor did he tell me his story. When he was talking with Mr. McKenna in the office, Mr. McKenna handed me the phone to introduce me, and I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know that it's painful. And he said, I'm willing to do it. And my comment to the court was in response only to the unfounded, irresponsible, and false assertion by Ms. Clark that Cordoba would never appear. She had no basis to say that whatsoever, as she has just shown with her own videotape. Now, I expect NBC to correct it, and somewhere down the line, I hope that this court record is made plain. Mr. McKenna is sitting right here, and he is available to get on the witness stand and assure the court that Max Cordoba said last night, okay, I now remember I spoke briefly on the phone. That's not an interview. Phillips could have saved himself some embarrassment if he'd bothered to pick up the phone and call me. NBC always finds me when they want to.
I am concerned, though, Mr. Bailey, that the statement, I have spoken with him on the phone personally, Marine to Marine, that sort of connotates something more than just, hi, how are you? I'm glad to talk to you.
I don't understand why you're concerned. You raised no question about what was said. I was simply, if you were reading the transcript correctly, giving you my assurance that I expected him to appear when called, that he was under subpoena, and that I did not think he would vanish, and that I had spoken to him and received an assurance on that alone. I do not interview witnesses. Good lawyers generally don't. They might be in a position of having to testify if the witness were to accuse them of something or tell a different story. Mr. McKenna is employed for that purpose. We happen to be in the same room when Cordoba called us, as his phone record will show, if he has made the call from a private phone and was billed for it. Now, you're perfectly able to explore this right now with Mr. McKenna, and I wish you would. And if you read the transcript carefully, I was reacting to the only thing that concerned me, because an offer of proof is an offer of proof, and the court has to accept it as that. But the court might be concerned that if cross-examination were put forth and the witness never appeared, that the damage would be done and you couldn't unring the bell. And it was my purpose to assure the court that I felt this fellow would appear based on his statement to me that he would. And that's all that transcript says, and you can't read it any other way. If you've got a contrary impression, I'm sorry. That was not my purpose. I wanted you to know that I believed he would appear, or I wouldn't put the questions. And that is the sum total on the subject.
And I think F. Lee Bailey is absolutely correct. He just said, I spoke to him. And for Judge Ito and Marcia Clark to say, well, that implies you had this big conversation. He didn't say I had a big, deep, involved conversation. He said, I spoke to him Marine to Marine on the telephone. Any inference they're getting from that is the inference that they're getting from it. It's not what he said. And Meggles says, what the hell is all that stuff on the judge's desk? Again, this is a result of media. This is a result of this being a sensational trial, broadcast gavel to gavel, one of the original things. Those are hourglasses. Little sand glasses, little hourglasses. Because he had one and he mentioned something about collecting them, and then viewers started sending him hourglasses and he started collecting them on his desk. That's kind of weird and kind of inappropriate, I think. And LSR Hakil Nu says, thank you, Jeff, for introducing this magnificent lawyer. You made me want to watch this trial just to watch Bailey and Marcia making a fool of herself. She's angry today, and she's kind of stepping in her own shit here too. But this was a result of a fight that started the previous day, and it spills into today, and it spills into the next day of the testimony. But F. Lee Bailey is magnificent.
All right. Thank you, Mr. Bailey. All right, counsel, we have an interesting situation here, not unexpectedly. Counsel, what
They're
we're going to
hourglasses.
do with regards to Mr. Cordova. Ms. Clark, where does Mr. Cordova reside? Where does Mr. Cordova reside?
He's not in the state, or he wasn't last night. We were unable to contact him.
What state does he reside in, Mr. McKenna?
He's not in California, I don't believe today. He resides in Bellflower, if that's a town. He has a subpoena.
When did he leave?
I believe he left either this morning or last night.
And when did you speak with him?
I spoke to him.
All right, Ms. Clark, I agree with Mr. Bailey's comment that television news broadcasts are not bases for the court to preclude at this time the offer of Max Cordova as a defense witness, unless and until I hear testimony from Mr. McKenna and Mr. Cordova himself regarding these issues. I think you agree with that. So at this point, I'm going to preclude any cross-examination regarding anything with regards to Max Cordova, which I had previously done, but I'm going to extend that prohibition through the remainder of Detective Furman's testimony. Under the California Evidence Code, a prior inconsistent statement may be offered as long as a witness has not been released from the requirement of providing further testimony under 770 of the Evidence Code. So if it should transpire that Mr. Bailey is correct in his assertions, then perhaps we will hear from Max Cordova. But unless and until I'm satisfied that the offer of proof there is a sound basis for it, I don't believe Max Cordova will surface. But I'll determine that at a later time.
Thank you, Your Honor. Mr. Darden needs to address the court on the matter of Alwyn Martin.
I was going to ask whether I could ask questions about Alwyn Martin because they had a tape recorded interview with her last night, we're given to understand.
We can
But
skip through a
I
little
would
bit of
like
this
a
here.
clarification of what the court is saying. You don't know whether Max Cordova is going to surface because you don't know if he will repeat what he said on television?
No, what I'm saying is that as far as this controversy
Yes.
that has since arisen, I'm not going to allow any cross-examination with regards to anything Max Cordova might or might not say unless and until we hear from him first, because there are some issues we need to resolve before he hits the witness stand in front of the jury, is what I'm saying.
Okay, before we get going, Herbert West says, it's crazy Judge Ito basically allowed Mark Fuhrman to be put on trial. Who gives a shit if he may have uttered the N-word 10 years ago? What a goddamn circus. No, it's absolutely relevant because the testimony was that he told this Kathleen Bell overheard him at this Marine Corps recruiting station saying that if he ever saw a black woman and a white woman together, he would pull them over. If he didn't have a reason to pull them over, he would create a reason, basically would fabricate a reason to pull them over. The idea is he's racist, and as a racist, when he's dealing with the murder of a white woman allegedly by a black man, he would be inclined to manufacture evidence. That's where the cross-examination is going. And then also, when he says, "Did you say these words?" and he says no, and then it comes out that they did, that goes to his credibility, and he lied on the stand. And if he lies on the stand, if he lies about one thing, you have the right to assume he's lying about everything. All of this could have gone away and probably would have had much less of an impact and could have actually helped with a conviction if he had just said, yes, I said these words a long time ago. I was an idiot. It was stupid, and I never should have said it. But he says, no, I never said those words. So either it's irrelevant or he's a liar and he's committed perjury on the stand. So it's a very, very relevant issue. It goes to bias. It goes to evidence manufacturing, to planting evidence, and it goes to his credibility as a witness. And that's what cross-examination is for. You're putting the opponent's witness on trial. You're attacking their credibility. You're trying to undermine their testimony, and he did it brilliantly and effectively. Fuhrman could have avoided a lot of this if he had been truthful. This isn't testimony. The judge isn't here. The jury is not in the room right now. This is before the jury comes in. They're arguing about whether or not to let certain witnesses in. They're arguing whether or not to allow certain pieces of evidence in. The jury is going to come in a little bit later. We've skipped ahead a little bit. So the jury will come in, and they'll start the day's testimony here in a bit. So now OJ Simpson's attorney, F. Lee Bailey, is going to talk about things. He wants to get demonstrative evidence in. Not evidence of what happened, but just visual aids. Because Fuhrman kept talking about his flashlight. And the flashlight he used was this tiny flashlight. In fact, F. Lee Bailey was very effectively mocking Fuhrman throughout the early part of his testimony about having a tiny little flashlight, a wee little flashlight, a little baby flashlight, and other detectives had big flashlights. and so, yeah, he was obviously, referring to his dick. It was a great innuendo, double entendre thing. It was brilliant. But he wants to bring these pieces of evidence in to demonstrate certain facts, to represent other things. And he talks about that here a little bit now. Oh, wait, before we go, we got to address one more statement here. If you watched last week, we addressed this in detail. Fuhrman always said that he was directed by the prosecution to say no when asked about that topic. Well, last week under oath, he was saying the prosecution never talked about that, never asked him any questions about that. They just had a little meeting where they asked, a few questions. They never asked about any racism thing. They never talked about it. So, he gets it. He was never coached on how to answer those questions. So, there's lots of things going on here. But let's get on to this demonstrative evidence thing here. Come on.
I would preview them for your honor rather than have to go to the bench in the middle of cross-examination. I have purchased a light which I believe is identical, or at least very similar to the one that Detective Fuhrman has described repeatedly in his testimony.
You described it as a AA, 2AA mag light, which that appears to be.
Yeah, and I would simply like to know from him before the jury comes in whether it is a replication so that it would be fair to use it in cross, in asking where he was holding it, where it was kept. I also have, which does not purport to be the same size of manufacture, a brown leather glove in a Ziploc bag that I would like to refer to in cross-examination without suggesting that it be marked as evidence unless the prosecution wishes that.
And now the reason he wants this particular piece of demonstrative evidence in is because during the next phase of the cross-examination of Mark Fuhrman, he's going to be mentioning that the glove was still wet when it was found, and he implies that the only way it could have been still wet when the glove was found is if it had been taken from the murder scene, placed in a plastic bag and transported to OJ Simpson's house. Otherwise, it would have already been dried at the time it was found. So he wants to show just like a demonstration of what a glove in a plastic bag would look like. That's the point of this here.
That be done as with the flashlight. The third item is I intend to ask Detective Fuhrman to name his 3 best friends. And I intend to do that in reliance on your ruling that that was a proper question for Rosa Lopez. We would like to talk to those friends.
Ms. Clark?
She gets snippy here too. She takes a literal low blow at him right now.
If it please the court, we tried to locate a copy of the Help Fuhrman letter that was referred to.
Okay, this is now we're talking about the letter involving the civil charges of defamation that Fuhrman has brought against people. In yesterday's testimony, they talked about this letter where his civil lawyer was saying, we've got $100,000 in expenses. We need help. This was like GoFundMe before GoFundMe was GoFundMe. His lawyer basically sent this to other police officers and lawyers and things saying, please send me money to cover Mark Fuhrman's expenses so we can move forward with this defamation trial. And that was one thing that was mentioned also in the last week was he filed defamation lawsuits against the defense team for saying he was a racist and for saying he may have planted evidence. He filed, if I remember correctly, defamation suits against certain media outlets for suggesting he was racist. But F. Lee Bailey went out of his way to mention that he did not file a defamation suit against the woman who said she heard him say the racist shit. And he didn't ask the next question, why didn't you do it? He just asked, did you do it? And left that implication because she was telling the truth. And that's where F. Lee Bailey has this masterful expertise. Don't ask the question you really want to ask. Let the jury ask it in their own heads. Let the jury answer the question. Let the jury ask and answer it. So you filed defamation lawsuits for saying you were racist against this person, this person, this person, this person, but not the person that actually said you said those words. And then he ended it. Because we know that truth is a defense, and the implication is if he files a defamation lawsuit against her, then she can prove it was true, and so therefore he will lose it, so he didn't do it. So that was a beautiful line of questioning. And Buggy says, legal advice, they say this proves the court system is broken. Everybody knows OJ was guilty. I would say the opposite. I would say this proves the court system does its job. Whether or not you know someone is guilty, they still are entitled to a fair trial. If the state is going to take away potentially your life in a death penalty or put you in jail for the rest of your life, they have a duty of proving beyond a reasonable doubt. And if anybody can plant reasonable doubt in the jury's mind, you should get to walk free. Those checks and balances in the court are there for a reason. They're there to protect the innocent. If you're not going to put on a fair trial, if you're going to manufacture evidence, if you're going to hide evidence, if you're going to do these things, then you should lose your case. I'm not saying that happened here, but I'm saying the process is the important thing. The state has the power to kill you. So even if someone is absolute, if you know beyond any doubt, if you watch them put a gun to somebody's head and pull the trigger for no reason, they are still entitled to a full, fair trial because the state is going to wield the supreme power to take away that person's life. And by protecting the rights of the guilty, you are also protecting the rights of the innocent. So next time an innocent person is there, you haven't just established a precedent where you don't have to give a fair trial. You can hide evidence. You can do these things. You are still maintaining the integrity of the court system and putting the court to putting the prosecution to their burden of proof. And this is what I believe happened here. The state was utterly out of their depth. They had shady witnesses. They didn't follow proper procedures. And by going through this, you are establishing that if they expect to take away someone's life, if they expect to take away someone's freedom for the rest of their life, they better damn well follow all procedures. They better follow proper protocols, proper procedures. They better not have shady fucks testifying on their behalf. So I think I would argue the opposite, that this proves that the system works, because the old adage is it's better that 100 guilty people go free than one innocent person go to jail. And that's where I sit on this. That's why we're going through this, is to show how you can cast reasonable doubt in a situation. And Herbert West says, I wish Vincent Bugliosi was the prosecutor in this case. He would have made F. Lee Bailey look like an absolute fool. I don't think he would have made F. Lee Bailey look like an absolute fool, because the prosecution's own witness is making himself look like a fool. It would have been a very, very interesting battle of wits. It certainly would have leveled the prosecutor defense playing field a little better than F. Lee Bailey and Marcia Clark. I would love to have seen a Vincent Bugliosi direct examination and an F. Lee Bailey cross-examination of Mark Fuhrman. And I wonder, I mean, if Vince Bugliosi had been the prosecutor in this case, if he would have put Fuhrman on the stand, or if he would have found some other way of getting this evidence in. Very interesting take, though. All right, let's get back to this letter begging from, and he wants to put him on the stand. He wants to put the lawyer who sent this letter out on the stand, because the lawyer said that Mark Fuhrman has incurred $100,000 in costs. And he's calling bullshit on that, which again is going to cast into question all sorts of credibility issues.
In the testimony, we have been unable to procure one. We have its contents described in this article, which was sent to us from Oklahoma. And as I understand it from Mr. Fuhrman, he has some knowledge of the letter that went out. I believe that if he does not have a copy with him, his lawyer, Mr. Tortolo, who, as we speak, is, I believe, on the 12th floor, prepared to watch his testimony. And I would like to request that the prosecution attempt to make that letter available before the cross is concluded. I would like the court to take a look at the basis of my request, which is this article.
Well, I think if Mr. Tortolo is on the 12th floor, I could ask the public information officer to go up there and see if Mr. Tortolo has a copy of that available.
I think we just asked him.
Ms. Hazlett?
Hey, Joe, if you want to pop on, I just sent you a link. Feel free or to join or not.
With respect to the flashlight, Your Honor, no objection. With respect to this plastic bag, this is ridiculous.
Now, she burns Bailey here. This is a low blow punch, a literal low blow punch.
With respect to this plastic bag, this is ridiculous. The Ziploc bag, for which there's no there is no connection to this case. A leather glove of a different size, a different color, a different make, a different style, that has no relevance to this case either.
May I see that?
Yes.
Thank you. When you say different size, what do you mean, Ms. Clark?
My size. And I think counsel even conceded that it's a different size. This is under 352. There is no valid probative purpose to this. I'm sure the court knows that what Mr. Bailey again intends to do is make another inflammatory argument with no evidentiary basis whatsoever in an attempt to confuse, mislead, and deceive this jury. This has no part in any search for the truth. This is a fantasy woven by the defense. for which there's no evidentiary basis, no logical or factual connection to this case.
Let me ask you this. What is the glove size that is on the glove that was recovered at Bundy?
Extra large.
Glove there is a Brooks Brothers size small.
Right.
They were out of extra large, Your Honor.
So they were out of extra large.
Not only that, but the glove in issue is an Aris, and it is not a Brooks Brothers. Can't even tell if it's a man's or woman's glove. Size small. I guess it's Mr. Bailey's.
No!
I don't know.
That was brutal. That was just brutal and uncalled for. This was 1995. Old school Mac boy. 1995 here. So that was brutal. It's small. Oh, it must be Mr. Bailey's. Boom. Ouch. Well, Ralph says, no, that was called for. Well, fair enough. Hey, another super chat rolls in. Thank you for the super chat. Everybody follow Bass and super chat. Looks like a chia pet. Oh no, dude, no. Don't say that. But thank you so much for the super chat. We like super chat. And don't forget, while we're sitting here at the 1 hour and 16-minute mark, we're just about ready to get into Mark Fuhrman's testimony. This little backbiting fest is just about wrapped up. We got 588 people here and 288 likes. So like half of you again aren't doing your job. So get down there and hit that like button. We need to get up to like 500 likes so we can get on YouTube's radar. That's a great thing. Do me that favor while we're in the process of bringing this trial back up. Hit the like button, hit the subscribe button if you haven't already. That's great. And make sure you get notifications because we've got a lot of fun stuff coming up. All right.
Size small. I guess it's Mr. Bailey's.
Ouch. Ouch.
I don't know what the relevance is to this case, Your Honor. I can't see any possible valid evidentiary purpose for the admission of such an item that bears no resemblance to the gloves in this case, or a Ziploc bag that has no absolutely absent from this case. No such evidence in this case whatsoever. And I think that the court should prevent these kind of theatrics that are misleading and inflammatory and deceptive in front of this jury.
What's your comment on the letter regarding Detective Fuhrman?
With respect to that, I'd object to the admission of the article. With respect to the letter itself, I have a real difficult time seeing the relevance of that, Your Honor. Mr. Detective Fuhrman has sought legal assistance for the purpose of defending himself as a result of the malicious attacks that have been made on him by the defense. In that regard, his lawyer attempted to defray some of the costs of his legal expenses. This was not a letter drafted by this witness, by Detective Fuhrman. It was a letter that went out by his lawyer that this witness apparently is not even familiar with enough to say what's in it or not in it. So that alone, I think, should preclude the use of it. I don't.
No, that alone is a problem. If your lawyer is sending shit out on your behalf and you don't know what that is, that's a problem.
See its relevance in this case. It does not show any financial interest in the outcome of this case that would be relevant to bias.
Wrong.
So I think under 352, that letter is of no probative value at all. I should also indicate that Mr. Bailey has given us no proof, no offer of proof even, as to how Detective Fuhrman, which I'm sure is the inference that he wants us to draw, put the glove that he found at Rockingham into a plastic bag. There's no offer of proof. There will never be any proof. There will never be anything but Mr. Bailey's theatrics, dramatic, albeit eloquent statements to this court that are absolutely empty of any evidence or any factual support. And that is why he is seeking to take a different pair of gloves, different style, different size, in a Ziploc bag that this case does not contain. There is no Ziploc bag in evidence in this case. He's manufacturing evidence. He doesn't like the truth. So he's manufacturing his own. And that's what this is all about.
Spicy.
And that's why this is the kind of thing that should not be permitted. May I have a moment, Your Honor?
Certainly.
Bring in the heat.
I don't know yet.
Or neither.
I don't know
We
yet.
don't know yet. I think that as far as the letter goes, I think we've gone as far as we need to go. Detective Furman indicated he was aware of the letter. He did not draft it. He's unaware of the precise contents of it. It was an article drafted by his lawyer. But counsel has received the admission from Detective Furman that he saw it.
Ask Ito if he's barren. You're brutal, chat. She just looks kind of reptilian. She kind of creeps me out. I know that's like looks shaming, but
Yeah, with respect to Detective, with respect to the letter, I think, no, I've said it. With respect to Detective Furman and the plastic bag and the glove that counsel now wants to admit, there is absolutely no evidence that Detective Furman put anything in any plastic bag on any time relevant to this case, June 12th, June 13th, or June 28th, or July, August, September, October, none. And so there is no valid purpose for the admission of that non-evidence.
All right. Mr. Bailey, any brief response?
Yeah, I responded to that, Your Honor. I take it there's no issue as to the three good friends. Just a couple.
Yes, oh, I'm sorry, I forgot to address that. Allow me, please, counsel. With respect to the three good friends, Your Honor, number one thing, we have a privacy issue as to those three people. I wonder if it's fair to have their names aired publicly for no valid purpose. With respect to the cross-examination of Rosa Lopez, I mean, this seems to be this kind of like a petty tit for tat. You did.
no. See this thing with the Rosa Lopez, the neighbor. They asked, who are your three best friends, and then so they wanted to talk to those three best friends. And Bailey's just saying, hey, I want to know who his three best friends are, so we can talk to them. And now she's bitching and moaning about that, saying, well, that's just a tit for tat thing, so he shouldn't be allowed to do it. He's just doing it. He just wants to do it because we did it. So what?
Did it, so we get to do it. They obviously don't understand. Mr. Darden was cross-examining Rosa Lopez because she claimed to have witnessed something very important, very significant concerning this case. And obviously, it would be logical for one to expect that she would tell that very significant observation and experience to her closest friends. And so that went to an important area of impeachment. What is the valid purpose of inquiring of Detective Furman who his best friends are? There is none. This is just a petty, vengeful kind of tactic employed by the defense.
How is that
If the
vengeful?
court is inclined to allow for this kind of nonsense, then at least allow Detective Furman to write them on a piece of paper and allow counsel to see those names. But I think there is no valid purpose for this. I really think it's just a petty, ridiculous kind of form of payback by the defense. There is no valid evidentiary purpose to it, as there was in the cross-examination of Rosa Lopez. I would like for counsel to perhaps give this court an offer of proof as to the relevance of Detective Furman's three best friends.
But I suspect Detective Furman's three best friends would be proud to be stand up and be counted.
I'm sure they would, Your Honor. I just want to give them the option of doing so. But if counsel wants to, something, as the court is well aware.
Why don't you ask Detective Furman if he has any objection?
I can.
And I would suggest, this is something that in most cases they're entitled to look into. Obviously, the people you want to talk are the people who know the person the best.
Right.
If Detective Furman has no objection to revealing that privately to you and to counsel for investigation purposes, then it's a non-issue.
I'll be glad to handle it that way. It's just that, we are all sensitive to the privacy issues that have been
Indeed.
foisted upon us, and I just
Indeed.
don't want to do that without anybody's say-so ahead of time.
All right, well, let's pursue it that way.
All right.
Your Honor, the letter Mr. Bailey alluded to a moment ago is here, and the clerk is making copies of that letter.
All right, thank you. Mr. Bailey?
Let me address the other issues and save that one until I get the letter.
All right.
To actually see it, the transcript, if it pleases the court, page 18, 750 and before shows that the witness knew about the letter. It was unclear as to his understanding of all of its contents.
Okay, so we can skip through this next little bit. I mean, basically, later the lawyer that wrote the letter comes and testifies about what's in the letter, because Bailey has some very, very pointed comments about it. After these comments, then we'll skip ahead to the actual testimony part of the day.
The flashlight is solved.
Yes.
Let me state very clearly, and I should point out that if Ms. Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory. But
strike back, boom.
Marines, if it please the court, have a habit. Most of them acquire as to where they carry things because of the nature of their duties. As please the court.
See, this is very interesting. I mean, after he slaps back at Marcia Clark for her memory, he makes a very important thing here, which I think is a point. I know we have Marines here watching us, and this is a thing that I've seen with my Marine friends. And F. Lee Bailey was a Marine. Mark Fuhrman was a Marine. The Cordoba, he was a Marine. And there was this was 1995. Fuhrman and they're Vietnam soldier era age. And so you get a lot of these service members here, and he makes a very important point about this.
Have a habit.
Oh, it will go back
clearly, and I should point out that if Ms. Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory. But Marines, if it please the court, have a habit. Most of them acquire as to where they carry things because of the nature of their duties. Drills and activities and the nature of the issued garments that they wear. The prosecution has opened this door rather deliberately, knowing full well that there would be questions as to whether or not the someone, and there has to be someone, who transported that glove to Rockingham could have been Detective Fuhrman. They were at pains to have Detective Phillips say that he never wore a coat or almost never wore a coat, suggesting that he would not have had the means to conceal the suspect glove had he acquired it. A generous offer would be to use both, the bulk of which exceeds the large glove that will be in evidence if they ever get through testing. The plastic bag, I think, is reasonably similar, and the witness can tell us, to those contained in the homicide kit in the car that he was driving that night or riding in. The rubber glove, which is here for a different purpose, is similar to the one that we have seen on Detective Lang and that Detective Fuhrman said was in the homicide kit and available to him. We have suggested that he has described with great differences a key trip to the body of Ronald Goldman. We suggest that most killers don't leave one glove at the scene and carry the other one to private property under any circumstances. And I suspect that every detective who's asked if he's had that experience will have to say no. So the likelihood is that when the killers left the scene, both gloves were there or both would have been taken. You have seen that the one glove, which is admitted in evidence, was under some leaves and not easily visible until the leaves were poked back. Detective Fuhrman described that as leaves cascading down over the glove and partially blocking the view of it. Assuming, since that glove is right against the fence, that the other one was seen several feet away from the vantage point on the north side of the fence in the shrubbery, where it would not be immediately visible unless specifically looked for with a flashlight. If that was spotted, even with this little light, which throws a pretty good spot for a short distance in darkness, how was it transported to Rockingham? Certainly the prosecution is going to ask that question. If it were placed in a bag, which would explain the reason that it didn't dry, and we will offer evidence to this court that had it been sitting out in the air at 60 degrees under the conditions which existed that night, it would have dried, and that will be given by someone who has seen the glove and the amount of blood on it and is an expert in such matters. So one way to explain its failure to dry would be to have it sealed off from the air. Detectives frequently, as we have seen in this case, collect evidence in plastic bags, something you were never supposed to do if you're dealing with blood, because everything that plastic bags do, as you will recall from an incident in the courtroom, to bloody objects is bad for evidentiary and detection purposes. Marines tend to carry things in their socks, the same way some detectives carry an ankle holster for a backup weapon. This package could easily have been kept in a man's sock, short or tall, for the length of time that would have been necessary from the finding of the glove, if it occurred when we believe it did, on his visit to the north fence, described in dramatically different ways on two different occasions, in ways that can't be reconciled. It could have been concealed up to the time that he bolted out of the house without telling anyone and making sure everybody else was occupied.
No, OJ Simpson's blood was not on the glove.
Did something which we believe explains the presence of the glove, the blood in the Bronco, etc. And we ask Your Honor to note that this man said that for 5 to 7 minutes, he investigated the side of the house
Alone.
wondering who dropped the glove and where he had gone, and failed to notice a set of steps and a door leading into the house. If that does not contradict any possibility that he occupied his time, as he says, I can't imagine a stronger contradiction. A door is hard to miss. And Mr. Fuhrman has experience with doors, as we will show you in the Gould case. Now, based on all that circumstance, I think it's fair to ask Detective Fuhrman if it would have been possible for him to put a glove in a plastic bag to which he had access and to stick it in his sock and to later pull it out and dispose of the plastic bag. Not a complicated question, not one he'll have trouble understanding, but a fair question, it seems to me. Because at the end of the day, the jury is going to have to decide between the choices given them, whether this defendant jumped over a fence or did something unreasonable and dropped a bloody glove on his property, whether a killer wishing to divert the police, and if this happened, he was eminently successful, from any attention to him, deposited the glove simply by throwing it over the fence, as is easy to do from the property where Rosa Lopez lives, or whether Detective Fuhrman, who well could have and had the motive, and we say the opportunity, carried that glove, from where he found it at the crime scene and deposited it in a way that would accomplish two things. Number one, it would keep him inexorably in the lawsuit. And number two, it would punish a black man who had the temerity to associate with a white woman in a romantic way. Now, that's the theory of the case, and I think that the evidence that we're offering to support it ought not to be excluded. I think the question goes to the weight. If Detective Fuhrman wants to say, the kinds of socks I wear are so fragile that they wouldn't have carried the package, that may be his answer. The question is, are we entitled to ask? As to the letter, I'm holding, I believe, does the court have a copy?
All right, we'll skip right after this little bit here about the letter.
It is a letterhead specially made up for this case, and it says Mark Fuhrman Justice Fund. It seeks financial contributions. And I respectfully suggest, Your Honor, that it's admissible for several reasons. First, Detective Fuhrman knew about it, and it was to his financial advantage if others would pay his legal bills so that he wouldn't have to. Number two, unless and until Mr. Tortolo can provide some evidence that the expenses, not fees, but expenses of handling Mark Fuhrman's representation in this case had caused him to spend $100,000 of his firm's money, as this says, then he has committed a rather neat violation of Title 18, Section 1341, mail fraud.
That is some serious shit there. Because he said he's incurred the $100,000. And if he's soliciting funds for expenses that have not yet been incurred while saying they've been incurred, he's lying. And therefore, Mark Fuhrman's civil lawyer is committing mail fraud. And that's what they want to hammer him on.
By trying to induce people to pay money on the ground that $100,000 had been spent. And if Detective Furman knows how that money was spent in representing him, in this case by Tortolo and Butler, I think he should be able to tell us. And if he doesn't know, then he should tell us whether or not he ever questioned this assertion before this letter was put in the mail to his fellow police officers to induce them to depart with their hard-earned income. I think that would be fair cross-examination, and that is the basis for further questions about this letter.
All right. Ms. Clark, you want to address just the letter, please?
Only the letter?
Yes.
All right,
That's
we
the
can-
only thing that we haven't discussed.
We can skip through this because later the lawyer that wrote the letter comes and testifies, and now we'll get Marky Mark and the Funky Bunch back here on the stand. The jury comes in, and then they begin the testimony, and then the hard R's start dropping. Super chat coming in from LSR. Hi, Call New. Jeff, you are the bestest best. Well, thank you so much for saying that. I deeply, deeply appreciate the super chat. Much appreciated. Thank you. Steph says, poor Marcia was in the middle of a divorce during the trial. She could care less how she looked, I guess. Well, she did midstream go through a pretty dramatic makeover. So there is that. To be Flair. Hey, to be Flair, what's up? When is the last time this guy killed someone and knows how a murderer decides why he decided to leave one at the scene? Maybe it's, I don't know, called being in a rush. Well, F. Lee Bailey has been representing murderers for about 40 years at this point, cross-examining countless police officers. And he probably has a lot of experience to draw from. And Amber Fox asked, Jeff, do you think he paid someone to do it? He has the money to do it. Again, I mean, my is I don't think he actually did the stabbing and slicing. Do I think he was there? I think there's a high likelihood he was there either when it happened or came shortly thereafter. Whether he paid someone, whether his son did it or whatever, I don't think he did it, but I think to some degree he was in on it. But the state did not prove that beyond a reasonable doubt. And notes on the phone. So wait, was it just one glove then? And no one questioned if it really was a one-armed man? Well, notes on the phone. You may have heard me talk about this before, but as you know, or may know, and if you don't know, you're going to know now, that one-armed man case that was served as the basis for the Tommy Lee Jones Harrison Ford movie, The Fugitive, where Dr. Sam Shepard goes home and finds his wife gasping her last breaths and reportedly sees a one-armed man running out of the house. That is based on a real case. The real Sam Shepard case exists. And F. Lee Bailey was the defense lawyer for Dr. Sam Shepard in the real case with the Richard Kimball, sorry, not Sam Shepard. Richard Kimball, you're correct. Son of Sam. Sorry, I got my cases mixed up. Yes, the Richard Kimball case. He represented Richard Kimball, the doctor who was accused of murder in The Fugitive. So that case you're mentioning, was it really a one-armed man? That real case was actually the case where F. Lee Bailey was the defense lawyer. Fun fact. The one-armed man case. But no, there. Yeah, so Sam Shepard's an actor. But yeah, I was confused. Like, there's also the Son of Sam murders. F. Lee Bailey. No, Jefferson, seriously. Yeah, seriously. The case, The Fugitive, Dr. Richard Kimball, it's based on a real case. The Harrison Ford, Tommy Lee Jones. There was also an older show in the late 50s, early 60s called The Fugitive that was based on that case where Dr. Richard Kimball goes home, finds his finds his wife gasping her last breath, reportedly sees the one-armed man. F. Lee Bailey was Richard Kimball's defense counsel in real life. So, yep, that's it's funny you should mention that. I'm pretty sure you heard me say that before. But yeah, for those of you that didn't know that, that's the true deal. But F. Lee Bailey, again, he has represented some amazing criminals like Son of Sam, David Berkowitz. He represented him. Patty Hearst, after she, the son of the Hearst Publishing Empire, the daughter from there who was kidnapped by the Symbionese Liberation Army and gave us the wonderful term Stockholm Syndrome. The Boston Strangler. Yep. He was involved in the Boston Strangler case. So yeah, F. Lee Bailey was the shit. He was the guy you called if you were accused of murder. Hey, it's relevant to this case. It shows you the people that he represented. I mean, the main criminal defense lawyers of that day were Melvin Belli, F. Lee Bailey, and Jerry Spence. You would go to them. You would look for them to get you some help if you had been accused of murder. So there we go. Just a little fun fact. We kind of got off on a little tangent there. Now we're going to bring the jury in, and we're going to get back to the testifying of Mark Fuhrman, the cross-examination of him, and see how this goes. While we're sitting here with the 605 viewers, 359 likes, we need to get up to 600 likes. So half of you, again, not doing your jobs, get down there and hit that like button, please. I deeply appreciate that. And the super chats for questions you definitely want read, statements you definitely want made, and hit the subscribe button if you're so inclined. But the likes, I would really, really appreciate your likes. I like me. Let's go.
Well, the isotoner or something like that?
Ms. Clark, what brand is it? I thought you told me it's Eris.
Eris isotone, okay.
Broadway.
Well, if we can get an extra large glove not used in the murder, would that be fair?
Yes.
All right.
It's the bulk that's the issue. And if you use
McKenna,
a small...
So anyway, the end of this glove in a bag thing is they allowed it in. They allowed him to use this as evidence of demonstrative evidence if they can get a glove of the same size.
I have to tell you where your duty lies.
All right. Thank you, counsel. Let's have the jurors, please. Madam Reporter, are you okay? Or
all right,
delay in
here we go.
This morning, there were a number of issues that I had to deal with this morning so far, perhaps 20 different issues that we've had to address, and I've had to make rulings on or make determinations and discuss things. And as luck would have it, it just takes a long time, some of these things. And
Taylor Cook, thank you so much for the super chat. Local legend is the Boston Strangler disappeared to my neck of the woods. Cool.
And I do have in the back of my mind constantly the pressure knowing that you're back there.
Yeah, we know the jury's back there.
There are
Hurry
just some
up.
things that I have to determine out of your presence. You stand undergoing cross-examination by Mr. Bailey. Good morning, Detective.
Good morning, Your Honor.
You're reminded you're still under oath. Mr.
Yes,
Bailey, you may resume.
Detective Fuhrman, yesterday you told us about a certain time that you were in a grand jury room with other lawyers whom you named.
Okay, someone's asking about Alan Dershowitz. Alan Dershowitz was an appellate lawyer for this. He was OJ Simpson's appellate lawyer. So in the middle of the trial, when they would have objections that went against them, then he would handle the appellate issues regarding those objections that had been ruled against them. He didn't actually do any of the testifying or any of the he didn't do any of the questioning during the trial in chief. He was in the background handling appellate issues.
Have you been able to recall the identities of any of the other people that you were unable to name yesterday who were present during this exercise?
No.
Okay. And I take it you've made no inquiry as to who they were then?
No, I haven't.
Is this the only time that you were questioned in a modified court setting, so to speak?
Okay, then what they're testifying about here is his preparation to testify. Lawyers will always go, I mean, not always, but in big cases and important cases, they will run their witnesses through a mock trial. They will put them on the stand and they will fire questions that are expected to be asked during cross-examination and prepare them for the cross-examining. So you'll try to make them angry. You'll bring up sensitive issues. You'll bring up shit you don't want them to bring up for the sole purpose of letting the witness know the potential questions that can come down. And that's what they did with Mark Fuhrman. They said, okay, let's come in this room. They put him in a courtroom setting. They put him on the witness stand. They asked him the questions that they expected F. Lee Bailey to ask him, or whoever was going to be asking him the questions under cross-examination. And he's talking about that process right now. Was he prepared? Was he coached? What questions did they ask? Who asked you the questions? And he comes off looking like an idiot again, because he's saying shit that you in chat, even as non-lawyers with no trial experience and no real relevant information, can tell is just intellectually dishonest, unnecessarily undermining his own testimony.
Yes, sir. How many other conversations did you have this year? I take it they were all this year, with Mr. Darden, Ms. Clark, Ms. Lewis, or other prosecutors about the forthcoming testimony?
Several conversations. I'd have a difficult time on numbers.
We have the same difficulty with the word several, okay? If you could use numbers, it would be much more helpful to us. Were you engaged in at least 10 different visits with the prosecution in preparation for this case, including the one in the grand jury?
I think that'd be the high number. I don't think it'd be that many. I'd feel more comfortable with maybe 8.
8 you think would be more accurate?
Yes.
And does that include this session that you described?
Yes.
Okay. Now, the subject matter of the session with the 3 lawyers was the Kathleen Bell problem, you told us.
Yes.
And that was...
And Kathleen Bell, she is the one that says she overheard the other guy and Cordoba in the Marine Corps office talking to Mark Fuhrman, and Mark Fuhrman dropping N-bombs on Mr. Cordoba. And that's it. Rubia, a wonderful lawyer that we all know and love. I will never forget watching this daily right after I graduated law school, lived in Los Angeles, police so crooked everywhere. Everyone there was for not guilty. So many backstories. Hey, Jeff. Yeah, that was between, the actual trial started the second semester of my 2L year, went through the summer, and then finished at near the end of the first semester of my 3L year. And I watched pretty much every minute, either skipping law school classes or videotaping it and watching it later. And when they read the verdict, they brought all the law students into the moot court room, into basically the auditorium, and we watched the jury verdict live. So yeah, I watched pretty much every minute of this trial, and it fascinated me. It's not the trial of the century, it's not the greatest trial, but you have some amazing lawyering going on with F. Lee Bailey here. And you maybe Ruby can throw up some comments as we go along here.
The sole purpose of this.
Again, this is the trial prep they're talking about. Questioning him. The sole purpose was to deal with the Kathleen Bell issue. Kathleen Bell allegedly heard him say these racist things. So the prosecution is going to be asking him about the alleged racist statements that are in Kathleen Bell's letter, which they refer to in the case as the Kathleen Bell problem.
Matter of the session with the 3 lawyers was the Kathleen Bell problem, you told us.
Yes.
And that was the sole purpose of this simulated cross-examination.
To the best of my knowledge, yes.
Okay. Do you have any understanding?
You be the judge.
The questioning that was done to you was to alleviate your concern over remarks you say you never made. What was the plan? Can you explain that to us?
No, I can't.
You can't?
No.
Well, were you told why you were being brought into that room?
No, it's a different woman.
To be confronted with cross-examination type questions.
All right, but I'm sure it was more explicit than that, wasn't it?
Concerning Kathleen Bell.
Concerning Kathleen Bell.
Yes.
All right. And were you told what they were hoping that you would do or not do when questions were put to you?
No.
Did any of the questions contain the name Kathleen Bell?
I don't believe so. I'm not sure on that, but I don't believe it did. No.
Did it contain the name of any other living person related to this case?
No, not that I remember, sir.
How many total questions do you say were put to you to address the Kathleen Bell problem?
Not very many. It'd be hard to estimate. It'd be also less than 10, I'm sure.
Less than 10.
Yes.
3 lawyers asked you a total.
See, this is intellectually ridiculous. And maybe Ruby can put a comment down here. He's being prepared for trial on a very sensitive racial issue where there's serious allegations of him being a racist. And he's saying that 3 lawyers had a special meeting with him to prepare him for trial, and they asked him less than 10 questions? I don't believe that for a fucking second. I would guess that they probably drilled him through N-bombs and drilled him and drilled him and drilled him for hours, trying to get him to piss him off, trying to look for his weaknesses, trying to find the holes in his armor that's going to trigger him and tell him how to deal with that. This whole idea that they called him in to deal with this issue of horrific racism and they only asked him less than 10 questions is absurd. And Rubio says, liar, liar, pants on fire. Yeah, it makes no sense whatsoever.
Not very many. It'd be hard to estimate. It'd be also less than 10, I'm sure.
Less than 10.
Yes.
3 lawyers asked you a total of 10 questions.
There was a lot of discussion between the lawyers. It just wasn't questioning.
My question was, do you represent to this court and jury that 3 lawyers asked you a total of 10 questions
Yes.
in this session?
Yes.
That would be 3 and a fraction per lawyer.
Yes.
Do you know any lawyer on this earth who is capable of asking only 3 questions?
Not currently.
Touche. Detective Fuhrman, how was it possible for these people to prepare you to confront the Bell problem, whoever brought it to your attention, myself or another lawyer, without using the words that you were claimed to have used in her presence? How did they do that?
I read some allegations. I believe it was on a declaration.
All right. Did you have in front of you a document filed in this court, signed by Kathleen Bell, alleging the conduct that we discussed before the close of court yesterday?
So are you talking about?
Now, if as I said, Kathleen Bell wrote a letter to the defense where she talked very, very specifically about the statements that Mark Fuhrman allegedly made to her, that she heard, and she quoted him and dropping the N-bombs, and that's what they're talking about here. Did you see this letter that she signed? We read the letter in the last I guess last Thursday. We read that letter, so you can go back and watch that and see what the contents of the letter were. Steph asks, why was he even put on the stand? Because the prosecution was using him because he found the blood on the Bronco. He found the glove. So he was a huge prosecution witness. But Bailey just poked holes in the methods and reliability of him finding those particular pieces of evidence. So we're getting into the dicey area here. And I think we're going to be okay. Because again, you hit the YouTube 2-hour mark and they tend to not really care what happens after that much. We're going to be getting close with the N-bomb questions. Should be coming about the next 5 minutes. That's why I'm kind of stalling a little bit so we can buy some time to get over the 2-hour mark.
Are you talking about what I viewed on the?
Yeah.
that letter in front of me? No, I did not
No,
have
no,
that.
I'm talking about a declaration that was filed in court by Kathleen Bell as an offer of proof.
On that day?
Sustained. Nothing was filed by Kathleen Bell in this court.
I'm sorry, not by Kathleen Bell, in her behalf as to what she would say.
In front of me that day, sir?
Yeah.
No,
What paper were you looking at that was the basis of the question? Did you
I
tell
was
us?
looking at no paper.
I thought something was read to you or that you read that you called a declaration. Can you tell us what you meant by that?
I had read it previously. I don't know when.
Were you familiar with its contents?
I read it once, yes.
Were you familiar with the language attributed to you by Ms. Bell in that declaration?
Yes.
Was any of that language the subject matter of the questions put to you by counsel?
They did not use that language, no.
What language did they use instead to help you with the Bell problem?
They used the term racial slurs.
Okay. Now, do you have any memory of even one of these 10 questions?
No.
Not a single one.
No, sir.
And this happened when, Detective?
Seriously, this is just complete and utter bullshit. He remembers he was asked less than 10 questions. He allegedly can't remember a single question he was asked during this very special witness preparation meeting where they brought him into a courtroom to simulate a cross-examination situation and asked him questions that he expected to be asked on cross-examination. He says he can't remember a single question. BS. Why is he doing this? Just say, yes, I remember every damn question. Then it takes everything out of the defense's arsenal. Yeah, so what? You ask the questions, and they'll say, what questions did you ask? And you tell them what questions they were asked. And then you tell them how you answered. There is no reason to say that 3 lawyers only asked you 10 questions and you can't remember a single question that was asked. guitar. Sorry, getting a little passionate. I apologize. I kind of just I yell. It frustrates me. Let's get back to the questions.
Detective Furman?
I believe it was 2 or 3 weeks ago.
2 or 3 weeks ago.
Yes.
Oh, now you have been exhibiting.
So it was 2 or 3 weeks ago, and he cannot remember a single question that was asked. Do any of you, even those of you that are 100% sure OJ Simpson did it, and those of you that are 100% certain in your beliefs that Furman did not plant any evidence, do any of you believe that he cannot remember a single question he was asked during preparation for his cross-examination only 2 or 3 weeks prior to this? Do any of you believe that? There is clearly no way I can believe that. All right, let me simmer down here. I wish I was drunk says, how are we? Apparently, I'm all worked up and I'm yelling at you guys, for which I apologize. And Ruby, oh, thank you so much, Ruby, for the super chat. That's so very nice of you. 1991, boyfriend, white polite Southern boy, LAPD, in front of 20 people beat him, causing permanent damage. They thought his car was hit and run. When cleared, 3 attorneys said, do not press charges because cops would kill us. Yee. LA was a pretty wild time back then. I mean, you had the Rodney King thing. You had the aftermath, the riots. A few years later, you've got OJ Simpson and Vince Clortho. Do what you do. Great morning TV for me. I watched the trial live while programming at home. So much I missed. Thank you for explaining it. Well, I'm just yelling at you guys. So yeah. See, nobody is believing this. Even I'm assuming some of you that are saying, no, you don't believe this, are people that believe that OJ Simpson is guilty, that he did it, that Mark Fuhrman didn't plant evidence. I mean, even, yeah. Anywho, Scott Hamilton, thank you so much for the super chat. Lee is well aware how Marines talk amongst themselves, and it means nothing. From the outside, sounds horrible. I was a grunt in 95. All races spoke trash. We'll get to that in just a second. We'll get to that in just a second. I mean, and by a second, I mean in about 3 minutes.
A startling memory for detail of a crime that was 8 months ago, have you not? Did any of the questions require you to say whether or not language of that sort was a part of your vocabulary?
I might have offered that.
Tell us, please, what it was you offered these lawyers in that room about your vocabulary, Detective Fuhrman.
Now, when we are entering hard R territory here for a little bit. Now, I want you to pay very close attention to the specific exact questions that Mark Fuhrman is asked about his use of language. And his answer. It was answers. And then we'll talk about it.
Overruled.
Would you answer?
Yes. That I don't use any type of language to describe people of any race, such as what is alleged by Kathleen Bell.
Here we go.
And you never had. Is that right?
Sustained. That question is irrelevant.
Did you say to the lawyers who were trying to prepare you for the Bell problem that you never used that language?
It wasn't asked. Sir.
Withdrawn. I'll be more specific. Did you tell the lawyers in that room that you never used the word nigger?
Overruled.
It was never asked.
I'm asking, do you?
Do I what?
That's vague. Rephrase the question.
Do you use the word nigger in describing people?
Presently.
Yeah.
Overruled.
No, sir.
Have you used that word in the past 10 years?
Not that I recall, no.
You mean if you called someone a nigger, you have forgotten it?
I'm not sure I can answer that question the way you phrased it, sir.
You have difficulty understanding the question. I'll rephrase it. I want you to assume that perhaps at some time since 1985 or 6, you addressed a member of the African American race as a nigger. Is it possible that you have forgotten that act on your part?
No, it's not possible.
Are you therefore saying that you have not used that word in the past 10 years, Detective Fuhrman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Fuhrman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Fuhrman?
Yes, they would.
All of them, correct?
All of them.
All right. Thank you.
That is an important part of this testimony. That is important. The question he was asked, have you ever used that word in the last 10 years? Ever? No. And he gets defensive. If anybody comes here and testifies and says that they heard you use that word even one time in the last 10 years, they are, by definition, a liar. And he got all upset. He's like, yes, they would. Yes, they would be a liar. I challenge you to find anyone who has not said the N-word one time in the last 10 years for any reason whatsoever, whether you're quoting Dave Chappelle, whether you're singing rap lyrics, whether you're quoting someone else, whether you're wondering why you can't say that word. Hubbleson says no relevance to anything. Incorrect. It is directly relevant to his credibility. Is he lying on the stand? Is he dishonest? Is he a dishonest police officer? Is he a racist? This goes directly to his credibility as a witness. He is saying, no, I never said this. And then in a couple of weeks, when we bring the receipts of him saying this, his credibility is shot. And he has committed perjury on the stand. And if you commit perjury on the stand, if you have lied about one thing, the jury is specifically instructed that they are allowed to discount everything he says. By making one lie on the stand, by lying about one thing, the jury is absolutely within their rights to consider everything he says to be a lie. You can't trust him on one thing. You can trust him on nothing. His lies destroyed the prosecution's case. It is directly relevant to his credibility as the person who found the evidence, the person who has allegedly said that if he doesn't have any reason to pull over a black man and a white woman, he will find a reason. He will make a reason. If he's dropping the N-bombs on them, if he's saying they should all be gathered together in one place and killed, if he's saying this, that goes towards his bias, that goes towards his credibility, that goes towards his character. And then if he lies about never saying that word, and it's proven that he lied about saying that word, you can discredit not only everything he said on the stand, but you can also throw out any evidence that he has found. And he found the blood on the Bronco and the bloody glove. So if he lied about that, you can remove the bloody glove and the blood spots from evidence. So, I mean, it is directly relevant to him as a witness, him as a police detective, him as a credible person. Now, there may be, I have said the word in the last 10 years. I've probably said it in the last few months, talking about this trial specifically. You Dave Chappelle, but he didn't ask, did you mean it when you said it? Were you quoting someone when you said it? Were he didn't ask for context. He just simply said, have you ever said this word in 10 years? Ever, ever, ever. And show me a cop, a Marine that hasn't said that word in the last 10 years, and I will give them an N-word medal. So this is a Marine, a cop, and a person who has never said this word in the last 10 years. If he had only been honest and said, yes, I have used this word in the last 10 years. I've said it. It was a stupid thing to say. I was trying to act cool. It was dumb, and I had no business saying it, and I regret it, and I will never say it again. This would not be a problem. But he lied. And that undermines his credibility. Just saying. And F. Lee Bailey, again, doesn't, well, if it was more than 10, he asked ever, and they objected to vague, so he limited it to the last 10 years. And again, when F. Lee Bailey asks a question, He knows the answer before he asks it. He knows Mark Fuhrman has used that word. He knows Mark Fuhrman has used that word within the last 10 years. And that's why he's asked those very specific questions. Have you ever used it? No. So if anybody comes and says you used it, they're lying. Yes, he's trapped him. Absolutely trapped him. And then we'll get that later in a week or two coming down the road. Let's continue.
Did you have any other training sessions of this sort?
I'm sorry, sir?
Did you have any other training sessions of this sort?
No.
Did you have other sessions wherein the word nigger was used between you and counsel?
No.
Never.
No.
Okay. Detective Fuhrman, I'm showing you what I believe to be a replica of the flashlight you described having carried that night. And I wonder if you could tell me whether or not it is substantially similar or appears to be.
Yes, it's exactly.
Appears to be marked. May this just be marked for identification or in case it's used later on.
1055.
And Jamie says he knew he would get him in a catch-22. Say yes, he's an evil racist. Say no, you're an evil liar. Exactly. That's how F. Lee Bailey's mind works. That's how good, if not great, if not legendary defense lawyers can plant the seeds of doubt in the jury's mind.
I realize it's light in here, Detective Fuhrman, but would you check that and see whether or not by rotating the head of the light,
Rotate the head, Fuhrman. Rotate the
turns
head.
on and off, and also changes its projection? Can you just point at a dark corner under the witness?
Yes, it does, sir.
Appear to function about the same way?
Yes, sir.
All right. We
I
can
hope
narrow
not.
the light to a spot. Okay, would you shine it on the screen? All right, now, would that light in darkness, Detective Fuhrman, enable you to see for a distance of 10 to 15 feet, do you think? To see an object?
I could see the object at that distance without a light. With the light, yes, it would aid me greatly.
No, in total darkness.
I wasn't in total darkness.
I understand.
Yes.
Well, I don't think you know yet what I'm talking about, which place
Yeah.
and time. Or have you assumed that I'm talking about your visit to the north fence?
No, I'm not assuming that.
Assume it.
Assumed.
Yes. Now, my question is, when you were at the north fence and you saw the glove that you referred to, perhaps mistakenly, as them in your preliminary hearing, were you able?
Sustained. Rephrase the question.
You saw one glove there, correct?
Yes, sir.
Did you look around the area at all in any way?
What area is this, sir?
The area near the fence. The glove was almost at the fence, was it not?
No, it wasn't. It wasn't even close to the fence, sir.
What was it close to?
It's close to the sidewalk.
All right, but wasn't there some railings nearby, near
No.
Goldman's body?
Yes. By Mr. Goldman's body, but not by the glove and the hat.
Do you recall saying that leaves were cascading down over the glove, making it difficult to see?
Yes, there was a plant that had leaves that went up and then fell down a broadleaf plant, and it covered portions of it. It was still visible, but it was clearly visible from the other side
All right.
of the north
Could
fence.
you see that without the aid of a flashlight?
You could see the objects, but not as well as you could with a flashlight.
All right. If you had shined that flashlight on that glove, the left-hand glove, would it have illuminated it better than the ambient light was doing?
Yes, sir.
Now, Will you describe the terrain immediately around the crime scene? And I wish you to eliminate the sidewalk, which is a
Right?
concrete or terrazzo.
Those were the
inlay.
days.
Are you talking
Yes. But what do you have? Do you have grass? Do you have plants? Do you have shrubs?
around Mr. Goldman?
No, around the area closed off by the fence being the one against which his body was kind of struck.
That's Mr. Goldman.
Yes.
Dirt, large tree by, I think, by his hip, buttocks area. Large meaning maybe 3 or 4 inches in trunk diameter.
Was there any other plant life growing in that area?
There was plant life, but I don't recall exactly where it was.
Was it similar to the plant that was partially covering the glove and the cap that we have seen in several pictures?
I don't recall, sir.
Did it stand about that high from the ground?
Indicating about.
I'm sorry, Your Honor. Yes, about 8-10 inches or more from the ground.
Which plant are you talking
I'm
about now?
talking about plants that were growing outside the fence enclosure where the crime occurred and adjacent to it.
Overruled.
I can't remember all the small plants in the area, no, sir.
Okay. Well, can you tell me whether or not immediately adjacent to that fence and in the general vicinity where the cap and glove and Goldman were located, there were plants sufficiently high to conceal another object the size of the glove it had been lying there?
Objection, that's very confusing. Compound.
Overruled.
I couldn't speculate on that, sir.
When you arrived at the scene that night, and I'm looking for something, so we'll come back to this and perhaps give you some help on your recollection. When you arrived at the scene that night, were you wearing a coat, jacket of some sort?
When I first arrived at the scene, yes.
Can you describe it?
Blue blazer.
And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove?
Yes, tan
that-
slacks.
Okay. Now, at some point, did you walk back to your vehicle and take off your blazer and hang it or lay it in the vehicle somewhere?
Yes, sir.
Okay, can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10?
It would be after I was relieved from the case.
All right, that would be close to 3 o'clock.
Yes, sir.
And that's when you walked back to the vehicle and left the jacket and stood waiting for your relief,
Yes, sir.
correct?
Yes.
Ten 10:56.
I'm going to show you what has been marked for identification as defendant's 1056, which is a photograph that you may recognize. Would you look at the monitor and tell me whether or not that is a scene that you have viewed before? Back it up. Does that depict the entrance to 875 Bundy with Nicole Brown Simpson's body lying in the rear?
Yes, it is, sir.
Your Honor, I assume the feed is off. I should have.
Yes, it is.
Now,
Mr. Harris warned me.
does that help you to recall the nature of the shrubbery which was to the north of the entrance walkway at 875 Bundy on that evening?
It didn't appear that way from the fence, no.
Well, did you ever stand in this vantage point on the sidewalk on Bundy, looking west?
Yes.
Okay. When you first arrived there, I believe in a similar photograph, you explained that you and Detective Phillips, together with Officer Risky, approached the gate post, which we see in the photograph, by going through the shrubbery off to the left of the photo and then entering the area shown by the photo and walking up to the gate post.
Yes,
Correct?
sir. Yes.
That would have given you ample opportunity, I take it, to view the shrubbery on the north side of the walk from a distance of a couple of feet. Did it not?
Not really, sir.
All right.
If
My understanding is you're at the gate post. Can you put an arrow on that, please? Just to make doubly certain that we're talking about the same thing. When you referred earlier in your direct testimony, Detective Furman, to the gate post beyond which you could not go without risking the contamination of evidence, is this the approximate area that you meant?
Yeah, a little more to the right, sir, was where Officer Risky was. In that area, yes.
Okay. From there, did you have a view across the walkway at the shrubbery that we see in the photograph?
In the photograph, yes, sir. This shrubbery, yes.
Are you suggesting that this shrubbery is different than the shrubbery that existed on the morning of June 13th?
No, if I could see a picture of from the north residence looking toward Mr. Goldman's body in a southerly direction, it would be easier to explain.
We are going to
See, and this is the interesting thing. Bailey just drops the N-bomb thing and moves on. And then Furman just continues to testify like he hasn't just been called a horrible evidence planting racist. He's just going about his testifying like nothing has just been dropped on the jury's head like a ton of bricks.
try and locate one, but for purposes of your present examination, can you tell me whether or not, from the position you were standing, if you looked across the walkway in a northerly direction, you could judge the height of the shrubbery that we see in the photo?
Yes, sir.
And was the shrubbery that we see in the photo substantially the same as what you saw when you arrived at 2:10 a.m.?
Yes, sir.
And would you agree that that shrubbery is fully capable of hiding small objects that might be dropped into it?
Yes, sir.
All right, thank you.
Overruled.
Can I approach the witness, Your Honor?
F. Lee Bailey gesticulating wildly. Tony G, clean and sober member for 3 months, says, I say, what's up, my ninja? Thank you so much for being a member for 3 months.
Detective Furman, before displaying it, I would like you to look at this photograph and tell me, if you can, whether or not that was taken looking in a northerly direction from the walkway at the base of the stairs in the approximate position where Nicole Brown Simpson's body was after the bodies had been removed.
Yes, sir.
Okay. The area to which I was attempting to direct your attention is on the right or east side of that fence. Now, in looking at that photo, does that refresh your recollection as to whether the glove and the cap were found close to the fence?
Yes, sir. You're talking about this fence that runs north-south.
That's correct.
Yes.
Okay. And you recognize this as being the area where Mr. Goldman's body was found when you were there?
Yes, this is the area I was referring to. It's somewhat cleared out.
May this be marked?
All right, People's 1050, excuse me, Defense 1057.
1057, Your Honor.
1057.
Bush did it, then hid the evidence. Nice.
The arrow on that.
I would like the arrow, Your Honor, so that I can point something out to the witness.
All right, proceed.
Detective Furman, we are now looking north inside the crime scene area after the removal of the bodies, or at least the body of Mr. Goldman, correct?
Yes, sir.
All right. I was and would you point out in that photo, and I'll ask Mr. Harris to put an arrow on it when you do, the area where the left-hand glove and cap were found?
Yes, sir. That's the area right there.
Okay, so that is fairly close to the fence, as I suggested, but you had in mind a different fence when you said it was not.
Yes, sir. I was talking about the north fence.
The north fence?
Yes.
And we are talking now about the east fence.
Yes.
Now, what I was trying to learn is this. Number one, with the spot of your flashlight in the ambient light conditions coming from the house, I guess, you fellas hadn't artificially lighted anything when you were there with spots and floods, had you?
No, sir.
Okay, you were operating with flashlights and whatever light could be gained from the open door of the house.
Yes, sir.
All right. With the little flashlight that you have been handling,
Bailey's back on this little flashlight thing. And if you go back and watch the previous, starting especially at the beginning of the cross-examination of Mark Fuhrman videos we did, he was just hammering so hard on his little tiny flashlight, the wee little flashlight, the little baby flashlight. He's starting on it again. Oh my God. Poor Bailey is just not letting this little baby flashlight thing go.
Yes, sir.
all right. With the little flashlight that you have been handling, been capable
With this little flashlight you've been handling. Oh, we all know Fuhrman handles his little flashlight.
of illuminating the area immediately outside the east wall of that fence, which is on our right as we look at the photograph.
Yes.
Okay. Thank you. Take it there. We neglected to print 1056 with the arrow where Mr. Harris put it next to the, I'm sorry. Mr. Harris is ahead. It is printed.
Back in the days of dot matrix printers, inkjets are just coming into fashion.
May that be 1056A, Your Honor?
1056A.
And the other one then would be 1057A.
Yes. Hard copies of each.
Hung like a tuna can? What are you guys talking about in chat? What? Nobody expects the F. Lee Inquisition. All right, we've just gone like full Monty Python in the chat here, it seems like. All right. Oh, you guys crack me up. You're the best chat ever.
Detective Furman, as best you can from your recollection, could you go through the meetings that you had with prosecutors since January 1 and simply tell us who was present and how?
Okay, we're back to the meetings he's been having with the prosecutor. And we'll just go a few more minutes here. And then we will We'll save more for next week. Next week, we should be able to hopefully wrap up his cross-examination and maybe even start in with, there's going to be a time jump after he gets off the stand. There's going to be a time jump of a couple of months to where we bring in Kathleen Bell and other witnesses to testify about what Mark Fuhrman said, and an additional session of Mark Fuhrman testifying outside the presence of the jury. But we'll get into that. Hopefully we'll be able to finish his cross-examination next week.
How long they took.
I've met with Mr. Darden.
All right, start with the first one you can recall. Do you have any date in mind as to when this first meeting with Mr. Darden might have taken place?
I believe I probably met with Miss Lewis before Mr. Darden.
Miss Lewis?
Yes.
Okay. And could you tell us when that occurred?
No, sometime this year.
Within the past week?
Well,
He was a hottie back in the day.
Frequently, because she's in the DA's office, but not all of the contacts were talking about anything to do with testimony.
Was any one lawyer at each of the meetings where testimony or the case, either one, was discussed?
No.
No, don't do that, Tony.
The first meeting that you had with Ms. Lewis,
just
when
click
did
it.
you estimate that it took place? In January, February, or March?
Cato has
I'm not sure,
a podcast now he's doing.
Can't tell us whether it was more than 3 weeks ago or less?
Well, I've talked to her several times over several months.
I appreciate that. But I'd ask that you use your best memory to inform us of when you first met with Ms. Lewis about this case, testimony or otherwise, and how long that meeting was.
I'm not sure. As far as motions, it could have been, I met her last year or talked to her on the phone, but I don't recall exactly.
Did you or didn't you meet with the prosecution last year about the case after the preliminary hearing?
I did not.
Oh, see, and again, this just makes him look ridiculous. He doesn't remember when he had these meetings, even though they were only 3 weeks ago. He doesn't remember the first time he talked to this person. Just, dude, it is unnecessary. This obfuscation is unnecessary. He thinks he's being cool. He thinks he's getting the better of F. Lee Bailey, but all he's doing is just fucking his testimony over and making himself look like an idiot and destroying the prosecution's case in the process. It is so unnecessary what his testimony did to the trial. If he had just answered the questions honestly, if he had just say, I met with him 3 weeks. It doesn't matter. And I don't understand why he's doing this. Bay says legal vices, Goldman's bruised hands and defensive wounds, as opposed to OJ's near death, bothers me the most about the state's case. And that's one of the reasons why I don't think he actually committed it, is because, a 46-year-old guy with arthritis takes out a strapping young 28-year-old guy and another woman at some distance apart from each other, quickly and quietly enough that the neighbors heard nothing, and he has nothing other than a small cut on his knuckle, which was supposedly covered by gloves at that point. That is bothersome. That's one of the reasons why I don't think he actually did it, but was there or paid someone or whatever. But James Andrew Morrison says, not now, Cato, you fool. Bringing some Pink Panther in here. Nice Pink Panther blast. Good on you.
I did not.
Well, what did you mean when you said I may have met her last year over the phone or otherwise about some motions?
Well, I might have been asked about something that's no longer part of this trial, or a motion that I get phone calls, sir. I don't write them down. I don't log them in. I don't know what to tell you.
You're a detective who doesn't always take notes.
I don't take notes about phone calls, or that's all I do.
Okay. Well, how many times did you speak with the prosecution on the phone as opposed to personally about this case, starting in 1994, if you can?
I've talked on the phone with prosecutors about when we could get together or meet. And that's kind of difficult because of the scheduling.
All that aside, Detective Furman, when did you talk with a prosecutor about a motion in 1994?
Sir, I don't have a day calendar.
Oral.
I don't have a day calendar. I write those memos in.
Just answer the damn question. I'm fighting for you here, Mark. You're doing yourself no favors. Your obfuscations and lies and things, they're serving no purpose other than to make you look horrible, to make the jury hate you, and to destroy the prosecution's case. Why do police do this?
I understand, but you have a memory. You remember this crime occurred in June of 94, don't you?
Yes.
All right. Now tell us as best you can, what was the motion that you were discussing on the phone?
Yeah.
Oral.
So there's been so many things going on with this. I couldn't tell you. When I talked to some people about.
Didn't ask you that. What was the nature of the motion that required that you be consulted, if you know?
I don't, sir.
Was it a motion about Kathleen Bell?
Oral. You can
I've
answer.
talked to
You can answer the question.
I've talked to Miss Lewis about Kathleen Bell's motion. Yes.
All right. And was that in 1994 when it was presented or filed?
It could have been.
Oh, Jesus Christ, how can you not know what fucking year it was you had this discussion? Was it this year or was it last year? There is no reason for him to be doing this. He is just destroying the prosecution's case.
Did you
Whatever.
talk on January 3rd when it was argued? Or thereabouts?
I don't recall a date. No.
Were you in the prosecutor's office in the month of January?
I believe so. Yes.
On what occasions? And start with the first one, please.
Sir, I cannot remember a date. I couldn't give you a time.
You kept no record whatsoever of your visits.
Why would I do that?
Were you on duty?
Yes.
Did you have to account for someone as to where you were going and why?
No. When the DA's office wants to talk to a detective, they obviously will talk to him. There's nobody that would need to give me permission. I just say I'm going to the DA's office.
Well, who would you tell? Someone had to know where you were, didn't they?
Yes, sir.
Well, who's your boss? Detective
Ron Phillips.
Okay. Did you tell Detective Phillips?
I just
on
get
those
so
occasions when you were
frustrated.
Coming downtown to work on this case where you were going?
Yes.
And do you know if any records of any kind are kept about these visits?
Not to my knowledge.
Are the prosecutors keeping any records of your visits that you know of?
I don't know, sir.
All right. Now, do you leave it to the court that if you had a meeting with Miss Lewis in January, you are not certain of it?
That's correct.
You just don't have any memory of meeting this woman in January, the one seated at the table here to my far right.
Sustained. Rephrase the question.
Okay. Try again. Did you or did you not see Miss Lewis in January in this building?
I'd say I could have, but I couldn't tell you exactly when, so I can't say for sure.
Is she the first lawyer that you met and talked to?
After the prelim?
In 1995. We'll just leave 94 alone for now.
I don't know if she's the first, sir.
You don't.
No.
Does anyone else come to mind as being the person who started off this whole series of interviews?
No.
Was it Mr. Darden?
He can't remember any of the questions he was asked 3 weeks ago. He can't remember who was in the room. He can't remember who the first prosecution lawyer he spoke with was. He can't remember what year he met with them. He can't remember if the only blonde prosecutor there was the first person he talked to. I mean, if you're being questioned and you genuinely don't know, say you don't know. That's a perfectly legitimate answer. But I mean, for Christ's sake, if you're saying you can't remember a single question that a court that was asked to you by the prosecution in a courtroom situation in preparation for testimony about you being a racist. If you can't remember one of the only 10 questions that were asked you 3 weeks ago, nobody believes that. Nobody believes that. Yeah, well, Megals, sorry, that's not the one I was looking for. It's Hubbleson. Seems to be that's what he's saying. He's saying it, but nobody is buying it because it's just absurd that you were brought into a room with 3 lawyers. You were asked only 10 questions in a courtroom setting with you on the witness stand, and you can't remember a single question that was asked of you 2 or 3 weeks ago. You don't remember the year you met with a particular person, when your only choices are this year or last year. It just looks so bad because nobody believes you. You don't take any notes. You don't have to recount for your time anywhere. It's just sad. Pope Rackets touched me, says, you expect this racist to not be retarded? Leave it to a racist to be so retarded to screw the case of a black man murdering a white woman. Exactly. You know, such coppery. I mean, if he had told the truth about the questions he was asked, I believe OJ Simpson would have been convicted. I'm just going to say that's just what I believe. But these lying about stupid, little, insignificant things totally undermines the case. Now, I'm looking for a point where we can stop this today. We'll get there in just a second.
No.
Was it Ms. Clark?
No.
Any other lawyers not seated here today that you've worked with on this case?
No.
Mr. Hodgman?
Oh, see, he doesn't remember who it was, but he clearly remembers who it wasn't. Ugh.
No.
Okay. So January, then, I take it, is a blank.
No.
May we now turn to February? Do you have any memory of coming to this building in February and meeting with someone?
Yes.
When was the first meeting in February that you can recall? Detective
can't.
Phillips?
I can't recall when in February.
I'm not asking for a date in a minute. Can you say early, middle, late? Give us any help at all?
I'd say it would be fair to say probably early part of February and the latter part.
No.
All right. Who was present at the meeting, the first one?
I've talked to Mr. Darden, talked to Ms. Clark, I've talked to Ms. Lewis.
Does that mean you cannot remember who was present at the first meeting?
That's correct.
And that was early in February, you think?
Yes.
Okay. When was the one after that?
I'm not sure, sir.
Early, middle, or late? Can you help us at least that much as to meeting number 2 in February, Detective Furman?
Sometime in the latter part of February.
All right. So you had a meeting in the early part of February, being the first one of that month. And you don't remember who was at that meeting, correct?
No.
And then you had a meeting at the latter part of February. With whom, if you recall?
I've talked to all these prosecutors that are seated before me.
All at once?
No, they work a team. I could talk to one. I could see another one the next day or the next hour.
Well, let's try and approach it another way. Of the 3 prosecutors facing you, with whom did you spend the most time talking about the case?
Probably Ms. Clark.
When's the first time you can remember seeing Miss Clark in a meeting that you attended in this building? In February?
I believe in latter part of February.
Okay. Do you remember how long the meeting was?
We didn't have many meetings or discussions that lasted much longer than an hour once we got started.
Do you remember the day of the week that the meeting occurred?
No, I don't.
Do you have any memory of the time of day that the meeting occurred?
It would be after court or maybe an afternoon. on a weekend, but I can't remember that period of time or day a week with the person.
Can't remember.
No.
Okay. When was the next February meeting you had after number 2 late in the month with Ms. Clark?
Sir, I don't know.
Don't know.
No.
But Detective Furman, when I asked you if you'd had 10 meetings and you said 8 would be more like it, where did you get that number?
I just felt 10 was too many. It just felt like I'm more comfortable with 8.
But did you pick 8 out of the air? Or do you remember having approximately 8 meetings with prosecutors?
Sustained.
Oh, see, I don't think that was argumentative. I mean, he wants to know why he said he had 8 meetings and he doesn't remember anything about the 8 meetings. Why he doesn't remember it being 9 or 10. But anyway, we'll call this a close here today. We've had a good run. We're coming up on 3 hours of the 2-hour deal. We just had to get through the racist bit, and then we're getting into the witness preparation thing, and then we'll kind of wrap it up with some more evidence planting thing next week. Hopefully, we'll be able to wrap up the cross examination next week, and then the following week get into the witnesses. Kathleen Bell, the script writer who met. Kathleen Bell was the one who heard him at the. Overheard him using the racist things at the Marine Corps recruiting station. And then a screenwriter who met with him that says he dropped N-bombs, and some of the tapes. So that hopefully we'll get to some of that next week and the week after. And then hopefully we can wrap up the F. Lee Bailey, Mark Fuhrman stuff and get into the amazing cross-examination of the criminalist Dennis Fung by Barry Scheck, which is some of the best lawyering you will ever see in your life. Wow. So again, just to make the blanket statement that I made several times every time I do this stream, I'm not trying to convince anyone to change their opinion as to whether or not OJ Simpson did it. Whether or not he's guilty, whether or not he's not guilty. You've all made up your minds. I'm doing this to show you how great lawyers, great defense lawyers plant seeds of doubt, plant the grounds for reasonable doubt in the minds of the jury. I wish I was drunk says his memory is as bad as mine. Mine is so bad I can plan my own surprise birthday party. I think he could probably do that himself. But yeah, I'm doing this to show you how great defense lawyers work. And F. Lee Bailey is one of the greatest criminal defense lawyers you will ever see in your entire life. And the next one we do, Barry Scheck. Barry Scheck is one of the greatest forensic cross-examination experts you will ever see in your life. That's why we're doing this, to show you how good lawyering, good defense lawyering, plants the seeds of doubt, the reasonable doubt in the minds of the jurors, which leads to a not guilty verdict. That's all we're doing. Maga says, I really like your hat, especially the color. Again, this is from Aron Sweater Market in Ireland. That's where I get my cardigans and my flat caps from Aron Sweater Market in Ireland. Hey, Aron Sweater Market in Ireland, you need to sponsor me if you ever happen to somehow be listening to this. I need more cardigans. Okay. Let's wind this thing down here. I'm getting a little bit excited there at the end by the unnecessary equivocation and deception and lying and allegedly bad memories of Mark Fuhrman. All right, what do we? I just want to wait a minute here. We have a incoming super chat from Vince Clortha. It's only 1 a.m. in Korea. Oh, that's late. Texas. It is 12:50 a.m. here. That's a thing. We've got to get some sleep tomorrow. I just want to pimp tomorrow a little bit here. Tomorrow is Fuck It Friday. If you are familiar with my Fuck It Friday, I do once a month, usually the first Saturday, the first Friday of the month. If not the first Friday, then the second Friday. Fuck It Friday is just where we have fun. Tomorrow we have a great lineup of guests that will be popping in. Some have said they definitely will be. A few say that they'll try to be here when they have time. We just meet with guests, we talk with guests, we have fun, and I grift. It's just a grift stream. It's a drunken, boozy grift stream. $100 super chats. I do a shot of premium whiskey. This time it will be a 25-year Glenfarclas Oloroso sherry cask aged single malt scotch that will crush me to drink in shots. A $500 bottle of whiskey, $100 shots. I take a shot of the premium whiskey, an amalgamation of less than $100 chats. Then I will drink a lesser whiskey. It's a grift thing. It's all in fun. $100 super chats. I drink premium whiskey. Less than $100 shot. We add them up, and then when it gets around 100, I'll do another shot. And it's just to grift hard, so I don't have to grift for the rest of the month, really. We're going to have some great guests. The guests we have lined up so far that have said they will pop in at some point are Drex. Drexel will be here. That Star Wars girl will be here at some point. Radix Vellum Christina, who was on my stream last night, she will be here. Aussie Overlord will be here. Meme Copium from Japan will be here. Farron from Farron Balanced will be here. Nina Infinity has said she will try to stop in, and Good Logic Joe, who was here in chat earlier today, has said he will try to stop in, and more may be checking in. Will membership gifts count as well for shots? Not tomorrow. All the stuff you want to give for memberships, give them for super chats. Tomorrow is just super chat grift day. That's all we do is super grift for super chats. Only super chats will count towards my drunken idiocy. And again, people are like, you're just grifting. You're just an alcoholic. It's totally in fun. Everybody is a willing participant. We just have fun. We're going to be talking about some great issues, some funny stories, and the guests. I've told the guests that plan on coming to bring one clip or one article that they want to talk about that's ridiculous and funny. So we'll just have fun, and it'll start at 10 p.m. Korea time, which is 9 a.m. Eastern, and that would be 2 p.m. London and midnight Australia time. Where it'll go from that point in time until I just become too intoxicated to continue. And if I'm not able to keep up with the drinks, I will do it again on Monday. We'll finish up the shots that I owe on Monday, but it's never happened yet. Last month, I cleared all 27 shots. My Saturday was completely fucking useless, but I cleared all 27 shots that you guys gave me last month. And the rule is 25% of whatever I pull in from Super Chats on Fuck It Friday goes towards next month's bottle. And so that's why we're drinking a $500 bottle of scotch tomorrow. Glenfarclas 25-year scotch. It's going to kill me. So yeah, that's what is fun. Steph better not be late tomorrow. Steph better be here. Steph's got to bring the grift. We're counting on Steph tomorrow. What about Corn Pop? What about Corn Pop? Corn Pop better be here. We need Corn Pop. And I wish I was drunk. Alcoholics go to meetings. You go to parties. Absolutely. But yeah, so that's what fucking I hope I haven't seen Brandon for a while. I hope Brandon is here. Brandon better be here. If anybody sees Brandon lurking around any super chats, let him know. I mean, any streams, let him know. Tomorrow is fucking Friday. So we're just going to talk about funny stories, things that we can just joke about. Things go right off the rails. And we'll have our guests. We'll have the super chats. We'll just go balls to the wall. Based conversation. All your favorites will be here. The people that nobody likes won't be here tomorrow. We'll have fun. And then next Monday also is Maritime Monday, which we do every Monday. And it will be a maritime incident with a whiskey tie-in. So that'll be fun. At least it'll be fun for me because I'll be drinking whiskey. Xcomer says post box. I don't have a post office box set up. I guess I should. I should go to the post office next week and see if they have any post office boxes available. Why not? Because if some of you are crazy and want to send me shit, that'd be fun. Brandon was in prison for money laundering. I hope not. Brandon is under a different name, I believe. Well, there's the whole Brandon Let's Go collective of 4 to 5 people that may or may not be one. All righty. Well, that's kind of it. That's where we are today. Thank you, everybody, for being here. On your way out, please hit that like button. We only got 472 likes. We didn't even get the 600 likes that I wanted. Come on, guys. Give me another 130 likes. Come on. And we got a few extra subscriptions. We're at 32,028 subscriptions now. That's awesome. Thank you so much, mods. Oh, Fedorovsky, that Glenn Farkless will be a good shooter. It's very smooth with no alcohol taste. That 25-year Oloroso sherry cask finished single malt scotch from Glenn Farkless is a gem of a whiskey, an absolute gem. And it crushes my soul, as I've repeatedly said, to drink that thing in shots. Sigh. All righty. With that, again, I just want to say thank you to the mods. Thank you to all the mods that were here. You guys did a hell of a job, as always. Thanks to the chat for keeping everything entertaining. Kaiser Pineapple says, can't wait for the Fuck It Friday. I'll be there. If anyone is available tonight at 9 p.m., I'll be streaming. Go to Kaiser Pineapple and his new stream. And Flux, also Mod Flux, she has started her YouTube channel. Go visit her. Go visit all these new peeps. And I will see you all tomorrow. Thank you so much for the super chats. And thank you to the people that just have this nonsense playing on in the background. And what I'm going to do now is I'm going to try to dump us all into Law Talk with Mike, who is streaming a trial of a extreme skier who is accused of killing a guy that he was supposed to be buying land from. It's a cool trial. I'll just dump you in there if you want to stick around. Watch LawTube with Mike. Law Talk with Mike. It's an interesting trial, like I said. It's kind of fascinating. I was with him last night. We'll dump you in there. If you want to stick around, stick around. If you don't, at least stay long enough to say hi and tell him that Legal Vices sent you. I'm setting that up right now. So where are we? We need Law Talk with Mike. Did he stop? Hang on. Huh. I guess he doesn't have the let people raid him thing set up. That's too bad. Because that would be fun. Anybody live right now? Nobody live that I've got right now. Everybody's just upcoming. So I guess we'll just end it. If you want, feel free to go over to Law Talk with Mike and tell him that Legal Vices sent you. Just go to YouTube and type in Law Talk with Mike. I will do this again just in case I had anything wrong here. Nope. All right. Go tell Law Talk with Mike I sent you, or go about your day. Thanks for being here. We'll see you all tomorrow for Fuck It Friday with our guests, our stories, and our booze. Love you all. We'll talk to you tomorrow. And until then, make sure you enjoy your legal vices. Law Racks out.